It's the Good evening. Welcome to the April 22nd, 2025 meeting of the Portsmouth Zoning Board of Adjustment. Okay. The first item of business is just a note that when you make your presentation, you are allotted 15 minutes. If you think you're going to go over, please let us know before you start, and we will vote to see if the extra time will be allotted to you. If you are speaking in public comments, then you have 5 minutes, okay? And I do want you to know, in case you're here for 86 Farm Lane, that the application has been withdrawn tonight. We didn't get a lot of notice either. So, the first item of business is old business, 84 Pleasant Street, and there is a second rehearing request. So, what does someone like to do with this?
Do we need to read it into the record, or?
I don't have the, oh, I do have the actual request.
Is this on your agenda?
Yeah, they updated it yesterday.
Oh, poop.
So there's a file that's called BOA packet
okay.
rev. It should be on your
This is the
download.
second request of Working Stiff Properties LLC for property located at 84 Pleasant Street and 266-27278 State Street to rehear the granted variance from the March 18th, 2025 BOA meeting. So, how are we feeling about a, is that a hint? No. Mr. Ray.
Well, I'll start, Madam Chair. Thank you. So I don't recall in the 12 years I've been on the board, we ever get a second request for granting a rehearing. That said, the applicant seems to believe and cites some applicable state law that indicates that they feel that if they're going to bring these issues forward and follow along court proceedings, that they need to appeal to this board first to be able to get an opportunity to then present them if this board refuses to grant a rehearing on that basis, to then be able to present those issues in any kind of appeal to into the court system. I mean, looking through what they brought up, my impression is it's things that are probably true, but I'm not sure that they are necessarily errors by this board. It simply talks to the fact that this board deliberated, that there were opinions brought up, that were contrary to the final decision of the board, which was to grant the singular variance that was the subject of that rehearing. There was certainly great debate amongst the board. It was a pretty split vote, but ultimately ended up being in favor of granting the variance. They also bring up the size of the board. I know that that's been somewhat talked about before. I kind of thought it was cool. I've never seen the actual 1958 verbiage from the state that allows this board, or 1953, that allows this board to have 7 members, vice 5 members, which is common for the rest of the state. But that said, I don't think it's anything necessarily this board has any jurisdiction over. I didn't see anything in the way that it was written that indicated that somehow this board's existence as a 7-member board is somehow a particular concern for this application. So my thought is we gave the opportunity for a rehearing. We listened, we debated, we came to a conclusion as a board. If the applicant, or in this case, the appellant, continues to feel that somehow the board did not come to the right conclusion, that's their prerogative. However, I don't see where this board needs to reconsider it again. They can advance that to the next level for consideration. Those are my thoughts.
Okay, thank you. Anybody else? Have anything?
When was the second request submitted?
I believe it was,
17th. The 18th, so it was a while ago,
It was-
because
it
I
was
didn't
stamped.
see it in the package I downloaded.
I mean, it was 4 days ago,
yesterday.
5 days ago.
In adequate time then, yep.
Yeah.
Yes.
I didn't agree with our original decision on this, so I would vote to rehear it, but I'm not sure there's the appetite on the board to actually rehear it. I would state that I also agree with Mr. Rayum that the composition of this board pursuant to state statute is not something that's within our purview. I assume that you're trying to preserve that for appeal to a court, but I would vote to rehear it, but again, I'm not sure anyone else wants to, so.
Does anyone else want to? Yes, go ahead.
I read the submission asking for a second rehearing. Even though I opposed, I was on the losing side in the last hearing. I'm not sure whether I opposed or supported the rehearing when you look at that. But I felt that the discussion was very thorough. I didn't see anything in this that would compel me to want to revisit those arguments. With respect to the membership of the board issue, obviously the city has been operating this way for 70 years, 72 years apparently, if I'm doing the math right. And I think if that's an issue that a court wants to overturn, a court will, but I am not convinced by the writing here that warrants a rehearing. I would not vote for a rehearing.
Okay. Would someone like to make a motion? Yes, Mr. Ness.
I move to deny request for a second hearing.
Is there a second?
I'll second.
Okay, thank you, Mr. Rayum.
My rationale, I think I just said, I didn't find anything in here that warranted a rehearing of what I felt was a very thorough discussion. Even though I was on a losing side, I didn't see anything here that I feel would change decisions or warrant coming back for another hearing.
Okay. Do you have anything to add?
No.
Okay. Any other comments? Okay, then we will vote. Mr. Neese?
Yes.
A yes vote denies the rehearing.
Yes.
Mr. Mantle?
Yes.
Ms. Margison?
No.
Mr. Rayum?
Yes.
Mr. Rossi?
I will admit I didn't see this in time to review it, so I will abstain from the vote.
Okay. Mr. Mattson?
Yes is to deny?
Yes,
Yes.
to deny, and the chair votes yes, so the rehearing is denied. Okay. And the next item of business is A, in new business. The request of William J. Armstrong, Jr. Revocable Trust owners, for property located at 70 Stark Street, whereas relief is needed to construct a detached accessory workshop structure, which requires the following. 1, variance from section 10.573.20 to permit a 10-foot rear yard where 20 feet is required. Said property is located on Assessor Map 159, Lot 50, and lies within the General Residence A District. Is there anyone to speak to this?
Yes, good evening, Madam Chair and members of the board. Chris Mulligan from Hopeful Phoenix here in Portsmouth. I'm here on behalf of William Armstrong. Mr. Armstrong is here behind me with his wife Karen. Also with me is Chris Redman of Mighty Roots, the design and build firm that prepared the plans that you see in your package. This is, I don't believe, a terribly complicated application before you. My client and his family have lived at this property for 25 years. This is a relatively large corner lot. It's almost twice the minimum lot size for this particular zone. About 15 years ago, there was a fairly significant addition added on, so there's a second dwelling on the property. And what we're proposing is to construct and site an accessory workshop in the rear of the property. I believe it's in the extreme southwest corner of the property. Even with the relatively large addition 15 years ago and what we're proposing tonight, we're still within the building coverage and open space requirements. Again, this is an unusually large lot for this particular neighborhood. That said, the setbacks pose a bit of a challenge to us, and that's because given that this is a corner lot, we have 2 front yard setbacks. That sort of pushes the available building envelope back from both Stark and Thornton Streets. And what we would like to avoid doing is having to squeeze the proposed accessory workshop structure closer to the existing improvements, so they're all on top of one another. So we're siting this in the deepest part of the lot. It's sort of a trapezoidal shaped lot, and we're siting it in the deepest part, but within the 20-foot rear yard setback. So that's the relief that we are here before you seeking. The proposal for this accessory structure is for a woodworking shop with some storage space on the second floor. I've noted in the materials that there is a similarly sized and relatively similarly sited accessory structure right next door at 245 Thornton Street, which is off of the side yard setback, but it's fairly similar in both size and character and siting to what we're proposing. So that's the sort of 100-meter overview. As you're aware, there's 5 criteria necessary to grant the variance. Unless you have any questions about the underlying project, I'd like to just get into those now.
Do you have questions? Yes. Mr. Neese.
I'm going to ask this question now. Maybe it's more appropriate for the staff at a future discussion, but I want to ask it just to hear your take on this. One of my questions is whether a variance is needed. Recently revised section 10.811.60 of the ordinance talks about any lot with 1 or 2 dwelling units is permitted to construct and maintain a 1-story detached accessory structure used as a tool or storage shed. I'm not quite sure this fits that definition, but it's close. And shall be generally exempt from all provisions of this ordinance. Are you doing this just in case, or
No,
has the city told you that you need the variances? For
Yeah,
this?
this was the variance that we believed we needed. I'm not familiar with that provision off the top of my head, and I think in any event, what we're proposing is more than a single story.
Oh, okay.
So I
Sorry.
don't believe we would apply, but I
And
defer
greater
to staff
than
on that.
120 square feet?
Yeah, it's 26 by 28
Got it.
building,
I missed that part. Thank you.
29 feet
Okay,
tall.
thank you.
Sorry.
That's okay, no. Learn something new every time.
There is another question.
So just for the record, which rear yard, the one off Stark or Thornton, are you asking for the relief?
The one off of Stark Street, it's a curious quirk of your zoning ordinance, but although you can have 2 primary, or 2 front yards, I believe the zoning ordinance properly only allows you 1 rear yard. That's why if you'll note on the plans, the extreme, I guess, eastern side of the property shows a 15 or a 10-foot side yard setback, because that is considered a side yard. under the ordinance. But that's always confused me. Okay.
Okay, Mr. Ram.
Sorry
Yeah.
about that.
Although I'm not a big fan of in the middle of presentation questions because it confuses your 15 minutes. I know Mr. Durbin loves doing this as well. So, my question is on sheet A3 and page 34 of our packet. It's your sheet A3. The storage area, there is a note on there that says unfinished space, parentheses, client to finish. What is the client's plan to finish that roughly 500 square foot space? Probably a little less than that.
I believe, and I'll have Mr. Thompson come up and explain, but I believe that's just a reference to him installing sheetrock and, doing the finish work.
Okay.
Just to keep the costs down. I mean, it is a woodworking shed, so he does have some skills.
Okay, thank you.
A nice set of tools. But I'll have him speak to that.
Thank you.
Okay. So in order to grant variances, obviously, we need to meet the criteria, and the first two criteria that the granting the variances would not be contrary to the spirit and intent of the ordinance, nor would it be contrary to the public interest, are considered together under relevant case law. The tests for meeting those criteria are whether or not granting the variance would alter the essential character of their neighborhood, or if granting the variance would negatively affect the health, safety, and welfare of the public. Here, the essentially residential character of the neighborhood would remain. All that is being added is an accessory structure. It's very similar to the accessory structure that's on the property directly adjacent to it, nearest neighbor. So the character of the neighborhood will not be in any way essentially changed or altered by what we are proposing. Health, safety, and welfare of the public will not be impacted in any way. So we believe we meet those criteria. Next criteria is that granting the variance will do substantial justice. This is a balancing test, and it requires you to consider the loss to the applicant if you were to require strict compliance with the ordinance against some gain to the general public. Here, I think the loss to the applicant would be reflected in the fact that if we were forced to comply and still build what my clients are proposing, we would have to squeeze the accessory structure up very close to the existing built improvements on the site. That would eliminate a fair amount of the usable backyard that my clients have for really very little benefit, in my opinion. This, again, is a very large lot for this area. It's almost twice the size, twice the minimum size of lots in this zone, and the project, even if it is built, still complies with all building coverage and open space requirements. So we believe substantial justice would be done by granting the variance here. Values of surrounding properties will not be diminished if the variance is granted. Here again, the immediate abutter has an accessory structure that's quite similar in size and location. This has had no negative effect on property values in the neighborhood, nor would this one. Finally, the unnecessary hardship criteria. Here there are special conditions of this lot. It's a very large lot. It's a corner lot. We're burdened by 2 front yard setbacks, which affects where the building envelope is. The existing structures leave little open space if we were to comply with, or little usable open space if we were to comply with the rear yard setback. So we don't feel that there's any fair and substantial relationship between the purpose of that setback requirement and its application to this property. The purpose of setback requirements generally are to promote adequate light, air, access, and separation of structures from one another. Here, to comply with the ordinance, at least on our particular property, all of those aims and goals of the setback would be frustrated because we would have a number of structures very close to one another for very little benefit. It's a reasonable use. It's an accessory use to a residential use in a residential zone. So for all those reasons, I believe we meet all the criteria and the variance should be granted.
Okay. Are there other questions now? Mr. Ray, did you have your hand up?
Yes, thank you, Madam Chair. Just to clarify, so on page 20 of our package, it's the map geo illustration showing your client's lot. It does look like the one sort of brown square, main large brown square they have on there for your client's lot would be indicative of just the primary residence. Do you know, is the current garage there an addition? If so, what, like, rough time frame that was added on?
Yeah, yes, thank you. The current garage was added on about 15 years ago. I don't have the tax card with me, but if you look on your staff report, the aerial map shows the addition.
Yeah, agreed. I was just curious that.
But it is 15 years.
The current status seems to be in conflict with what MapGeo has. Obviously, it takes a while for those
That's
sorts
correct.
of documents to get updated, so I was just curious.
Yeah, that's
Thank
right.
you.
Ms. Murchison, did you have a question?
Yes, just a question about why it has a garage door.
I'll let my client speak to that, but, it's not uncommon for a workshop to have the need for access large pieces of machinery, plywood, et cetera. So that's really the only reason I can think of.
Okay, thank you.
I guess that's it.
Right. I think I just have Mr. Thompson come up and answer those questions that were asked, if that's okay?
Yes, yes.
Hi, I'm Bill Armstrong, the owner. So if you have any questions for me? You asked about the garage door. It's actually not like a upright overhead garage door. It's more like a barn door, like this. You can't really tell from the picture.
Okay. Was there another question? Yes.
Yeah, so my question was just, the plan indicated finishing the second story will be done by the client. Just curious as to what your intent is for that space. It's listed as storage. Just trying to understand what you anticipate that is going to entail.
Yeah, well, my wife and I got married later in life, and we both accumulated quite a bit of stuff, so it's just pure storage up there.
Okay.
And I'll pick away at that project for the rest of my life, probably. Putting up sheetrock and making use of the workshop down below.
Okay, thank you.
Anything else?
Okay, thank you. Okay, are there any other questions? Okay. Is there anyone in the public to speak in favor of this petition? Is there anyone to speak in opposition to this petition? Is there anyone to speak to, for, or against? Okay. Public hearing is closed.
I
Yes,
just have a
Mr.
question for staff. This is considered 2 stories because of the dormer, or because to me it's within the roof line on the second?
Yeah, I think they noted it as 2 stories. It's probably more like 1.5.
Okay, that's, yeah. But similar, okay, thank you.
Yeah, the description says second floor storage, so
Yes,
in the shed description.
right. And then also the site plan said second, or it said 2-story,
Yeah.
but I suppose it might be more of 1.5, but similar, okay, fair enough.
So what would we like to do?
Oh, I see somebody with a hand.
Ms. Murchison?
I would move to approve the variance as presented and advertised. If I get a second, I'll go through the criteria.
I'll second that.
Okay.
I was going to give it to Mr. Mantle, whose hand was raised, to show that I now remember his name. Mr. Mantle
Fair enough.
has the second.
At least you got the name right.
So going through our criteria, the first two, 10.233.21 and 10.233.22, granting the variance would not be contrary to the public interest, and it would observe the spirit of the ordinance. I find that this variance request meets both of these criteria. The reason for the side yard, front yard, building envelope setbacks is to ensure the movement of air and light and through the structures, and also to, and distance between the structures, and also another analysis that you can apply to this criteria is that it would not alter the essential character of the neighborhood, and it would not threaten the health, safety, and welfare of the public. This variance criteria would not do either. There are the applicant has submitted examples of other structures, other property and lots in the area that also have these accessory structures. The third criteria is 10.233.23. Granted, the variance would do substantial justice, and I find that it meets this criteria in that we have to see if the hardship upon the owner applicant outweighs any benefit to the general public in denying the variance. Then substantial justice would be done by granting the variance. I don't see that the public, through the substantial justice prong, will incur any kind of loss as a result of granting this criteria, whereas the impact on the applicant would be somewhat substantial. Next criteria is 10.233.24. Granting the variance would not diminish the values of surrounding properties. And I find that it has also met this criteria in that we haven't had any expert opinion on whether or not it would diminish the value of surrounding properties, but applying common sense, and also it's an accessory barn structure, it would not impact property values in the neighborhood negatively. And then the last one, which is 10.233.25, literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. And here we have to determine, 1A, if the property has special conditions that distinguish it from other properties in the area, and B, owing to these special conditions, a fair and substantial relationship does not exist between the general public purposes of the ordinance provision and the specific application of that provision to the property, and the proposed use is a reasonable one. And I'll take this in turn. The property does have special conditions. It is a rather large lot for the area. It does have 2 front yards. It is irregularly shaped. The existing structures on the lot make it difficult to site this accessory structure. And because of these special conditions, a fair and substantial relationship does not exist between the general public purposes of the ordinance and the specific application to this property, given its large nature and the fact that it has 2 front yards and, again, is a irregularly shaped lot. And the proposed use is a reasonable one. The barn, the wood shop, woodworking structure the workshop structure is allowed as an accessory use under the zoning ordinance. And with that, I would recommend approval.
Does the second have anything to add?
As far as the approval, no. I would like to add a stipulation, if the maker of the motion agrees. I would like to add that only electric utility can be connected to the barn, no gas, no plumbing.
And the purpose of that is?
I don't want it to be turned into a living unit without them coming back here.
I think, so you're thinking of like a second
Accessory.
dwelling unit or an accessory dwelling unit? Is an accessory dwelling unit allowed in general residence A? I'm not sure.
Well, that's superfluous. We approve this, the unit's there. But it can't be a living unit without plumbing or gas. Electric, I can see, it's a workshop. I mean, that's fine.
I think I'm reluctant to accept the stipulation because and I don't know off the top of my head if an ADU, detached ADU is allowed in the general Residence A, but if they are, then we're taking away something that's allowed by right. Or I think it's a cup.
Well,
think
they
it
would
is.
have to come back here to get permission for an ADU, for plumbing, for stuff like that.
I
Or
think
at
that
least
would
the
be the
planning
planning
board.
board.
Yeah, that's not us.
But still,
Just need to check the zoning ordinance.
All right, Mr. Ram has something to it.
Not to usurp the staff's, if you have it, you can talk to it, but
It's allowed by CUP in the GRA.
up to 600 square feet, actually, we're in GRA, correct?
Yeah,
Yeah,
GRA.
it could actually be an administrative approval.
I think this is over.
So, and
it's up
does
to
this,
750 detached.
meet
Part
the,
additional use
how big is this accessory structure?
It's over 600.
Over 600 square feet.
I was, yeah.
Okay, so it couldn't even be a detached ADU then,
No, it could,
It could with a
could.
conditional use permit.
conditional use.
with a conditional. I would not accept the stipulation because I think that with a CUP, this can become a detached accessory dwelling unit.
I withdraw my second.
Okay.
That's my only concern for this approval.
Think- Okay, I've never had anyone withdraw a second. Should we look for another one?
Madam Chair, I reiterate my willingness to be the second.
Well,
on
thank
this.
you, okay. Mr. Ram, do you have anything to add to the motion?
I do. This property does have already a lot of structure on it. But I think it's important that, as the applicant's attorney has pointed out, this is, still within the allowable building coverage. Amazingly enough, it seems like there's a lot of stuff there. But they're within that, so I think that makes me feel much better about the application. And then the fact that it's 10 feet off of the rear property line, I think is important. It kind of mimics the side yard requirement, and I know the rear yard is 20 feet, not 10 feet. But that said, I think it is trying to create like a symmetry with the property line, which I think is important. And it's also parallel to an outbuilding on the neighboring property, which I think is a consideration as well. We're always worried about casting of shadows and whatnot. Really, the neighboring property already has a structure there. It's not like it's going to diminish their enjoyment of an open space where they would be looking for sunlight. I mean, this is not a tiny structure that's being added. It's got some size to it. But that said, with those considerations, I do believe it meets all of our criteria and should be granted.
Okay, thank you. Is there any further discussion before we, yes, Mr.
Yes, I'd
Rossi?
like to make a comment. I will not be supporting the motion, and my rationale for that, just for the record, the special conditions, in my opinion, of the property being, let's call it oversized and trapezoidal in nature, mitigate against this variance, not for it. The larger lot size really calls into question why you would have to encroach upon the setbacks at all, and particularly on the side of the lot that is the deepest relative to the Stark Road, Stark Street frontage. So I think that this is sort of a at least in terms of this structure, a greenfield design where the applicant has decided that it needs to be 28 feet deep and that it shouldn't be any closer to the existing garage. Those are their own design decisions that I don't think are really driven by the special nature or special characteristics and features of the lot itself. Therefore, I cannot support the motion.
Okay, thank you. Mr. Ram?
Yeah, I think Mr. Rossi actually has a good point. It's something that was in my mind as well. There's certainly opportunity here potentially to move this structure forward and put it within the envelope. That said, I do think that would be perhaps an overall diminishment to the general public purposes of what we're trying to accomplish here, in that it's now going to be more pronounced, more something that passersby are going to see. I think the placement that the applicant has submitted, which admittedly requires relief, as I indicated, I think it does make logical sense for this particular parcel. I think one of the unique aspects of this parcel is that it is taking advantage of this sort of the symmetry with a neighboring parcel, and also that you know, as we've talked about, it is kind of odd that we have 2 front yards, but not 2 side yards. You know, that sort of does work against the applicant in this case as well. In citing this particular structure, which again, there's plenty of overall square footage to allow the structure in this particular location. So with that, while I do believe Mr. Rossi has a valid point, I was able to overcome it and recommend approval.
Thank you. Okay. With that, are we ready to vote? Okay. So a yes vote allows the structure. Mr. Neese?
Yes.
Mr. Mannel?
No.
Ms. Margison?
Yes.
Mr. Rain?
Yes.
Mr. Rossi?
No.
Mr. Mattson?
Yes.
And the chair votes yes, so you are approved. Okay, the next item of business is B, under new business. The request of Paul and Carolina Rogenbach for property located at 2 Sylvester Street, whereas relief is needed to construct a second dwelling and associated driveway on the lot, which requires the following. 1, variance from section 10.513 to allow more than one freestanding dwelling on a lot. 2, variance from section 10.1114.31 to allow a second driveway on the lot. And 3, variance from section 10.521 to allow a lot area per dwelling unit of 7,899 square feet, where 15,000 square feet is required. Said property is located on Assessor Map 232, Lot 35, and lies within the Single Residence B District. Welcome.
Thank you. Good evening, Madam Chairman and members of the board. Sorry. I might go like a minute over. Maybe I'll try to be quick.
Okay,
My name is Carolina Rogenbach. I'm here with my husband, Paul, and we are the owners of the property at 2 Sylvester Street. We're here to formally request the several variances to allow the construction of a secondary dwelling on our property. Specifically, we're seeking variances from section 10.5131 dwelling per lot, section 10.521 lot area per dwelling, and section 10.1114.31 for driveways. The proposed secondary dwelling will be located on the southeast side of our property. It's marked in blue on the plan, to the right of our primary residence. It will have a footprint of about 1,252 square feet, with 2 bedrooms and a bathroom, totaling the gross living space of about 1,002 square feet. It will be above a 3-car garage, and the reason for the 3-car garages is that one of these garages is meant to be for us to use as our little shed / garage, is like not fit for modern day cars, and the 2 other garages would be intended for the tenant of the secondary dwelling. The proposed dwelling, we don't just want to put it as an investment. It will serve a vital purpose for our family, because at first we would want to use it as a rental property, which will provide essential income to help offset significant costs associated with my husband's long-term medical diagnosis. And looking ahead, like maybe years down the road, hopefully, I think one of our sets of parents, once they retire, they would move in there to be closer to us and help out. We believe that the request for these variances meets all the necessary criteria outlined in the zoning ordinance, and we would like to elaborate on these. Firstly, the variance will not be contrary to the public interest. In fact, we contend that it will benefit the public by providing a much-needed housing within our community. It's situated on a quiet dead-end street within walking distance to the West End and downtown. It will not negatively impact public health, safety, or welfare. The secondary dwelling will be designed and built to be compatible with the character of the neighborhood, preserving its residential feel. It won't lead to overcrowding or excessive traffic or undue noise, and it will maintain adequate air and light for the surrounding residences. And we believe it will actually improve the aesthetics of our street by filling what is currently like a large, flat, empty space between 2 homes, which looks like a building may have been there at some point, maybe was dozed, and now it's just kind of an empty lot. Secondly, the spirit of the ordinance will be observed. We know the core intent of the zoning ordinance is to promote the health, safety, and general welfare of Portsmouth and its region. It will not disturb the well-being of its neighbors in any way. Granting the variances will be consistent with the existing neighborhood fabric. Many adjacent and neighboring lots are indeed smaller than ours and already feature multiple driveways for single dwellings or accessory dwelling units. Given the size and the specific conditions of our property, this proposed use is entirely reasonable and in keeping with the neighborhood. Thirdly, substantial justice will be done. Denying this variance would prevent the reasonable use of our property and could devalue it and render a portion of our land impractical and unusable. Granting the requested variance would be just, especially considering the neighboring properties, somewhat smaller than ours, already benefit from accessory dwellings and second driveways for single residences. This would have no significant adverse impact on any neighbor, and there's no harm to the general public. It would allow us reasonable use for our property, a use that has been permitted other residents on Sylvester Street and adjacent Marjorie Street. Fourthly, the values of surrounding properties will not be diminished. In fact, we believe that this project may enhance the value of the surrounding properties. Currently, the proposed location of the secondary dwelling, as I mentioned, appears like as a very flat, empty lot, like something's kind of missing there. That would allow us to utilize this space in a fair and reasonable manner without creating obstructions for our neighbors and would be consistent with lot sizes prevalent in our area. Granting the variance from one dwelling per lot and the necessary second driveway will fill this empty space, improving the overall aesthetics of our street. Our intention is to create a structure that blends with the established character of Portsmouth and the Seacoast area. So we envision a Dutch colonial style with a gambrel roof that is quite common in this area. We think that the new construction would even improve the acoustics of Sylvester Street due to the low-lying like nature of Sylvester Street. It's like down a steep slope from Middle Road. It has kind of like a hill on one side surrounded by trees. It's kind of like creates a bowl, and there's a lot of echo. It echoes loudly just when you're standing there talking. So the secondary dwelling would actually act as a barrier mitigating some of the echo effect. And there are also mature trees bordering our property where that dwelling is. So that would ensure that the new dwelling isn't causing obstructions because there are already trees kind of providing a privacy for the other neighbors. And finally, literal enforcement of the provisions of the ordinance would result in unnecessary hardship. The hardship arises due to the special conditions of our property that distinguish it from others in the area. Our primary residence was built on the lot in 1930s, predating the city's current regulations, and with that, our intention is to make the most efficient and sensible use of our property while we fully respect the spirit of the ordinance. We are requesting variance from section 10.5131 dwelling per lot in conjunction with variance from section 10.521 lot area per dwelling unit. Our current lot size is 0.36 acres or 15,798 square feet. This is not only larger than the minimum lot size in the SRB zone, but also significantly larger than many adjacent and neighboring properties. As our survey shows, our lot is wide, but it is relatively shallow and essentially encompasses the equivalent of 3 lots like along the backyard northeast side on Marjorie Street. Even if we were to conceptually divide our lot into 2 for the primary residence and the secondary dwelling, each portion would still be approximately 7,899 square feet or 0.18 acres, which is larger than several of the neighboring properties. The property at 1 Marjorie Street, which is directly behind our existing house, is only 0.07 acres, which is less than 1/5 of our total land. The property at 610 Middle Road and 3 Marjorie Street, which is the corner lot behind our house, and then the third one down on Marjorie Street, are .14 and .15 acres respectively, which is less than half our size. Property at 6 Sylvester Street, which is our neighbors just to the right of our house, has about the same property as ours at .37 acres, already has a detached ADU on a section of land that is approximately the same size as the envelope on which we would like to build our project. And similarly, the property across the street from us at 1 Sylvester Street also has .37 acres, features a detached accessory dwelling unit as well as a pool and a pool house. The substantial size of our lot readily accommodates 2 dwellings while remaining consistent with the character of the neighborhood. We have carefully calculated the building coverage, including the proposed secondary dwelling, and it remains approximately 18% of the lot, which is within the maximum allowable under the zoning code. Further, we are requesting variance from section 10.1114.31 driveways to construct a secondary driveway approximately 18 by 40 feet made of asphalt to specifically serve the second dwelling for the 3 garages. This additional driveway is essential to provide dedicated parking for the tenant and direct access to the garage. The existing driveway's location that we currently have, the size and its configuration do not provide adequate and safe access for the proposed secondary dwelling. Second driveway is necessary to minimize potential traffic congestion like on the driveway and enhance safety for both the main residents and the occupants of the secondary dwelling. Utilizing the existing driveway for a secondary dwelling, that would eliminate off-street parking for our house, and that street is, narrow as is, so there's no, you can't really park cars around there on the street, and it would create an unsafe driving in and backing out situation. A separate driveway will allow for distinct ingress and egress and provide 2 dedicated off-street parking spaces for the occupants of the secondary dwelling. The proposed location of the secondary dwelling, its required parking spaces necessitate the secondary driveway to maintain the aesthetic appeal of the property and ensure functional independence for both residences. It's important to note that adjacent and neighboring properties with similar or even smaller lots already have 2 driveways, some serving a single house. The property on Sylvester Street, which is our neighbors to the right, have a secondary driveway for the detached ADU at 4 Sylvester Street. The neighboring property at 3 Sylvester Street, which is diagonal, you only see the little corner down there, on a 0.15 acre lot, has 2 driveways for a single residence. The property adjacent to our backyard at 610 Middle Road, which is the corner property on Middle and Marjorie, on a 0.14 acre lot, also has 2 driveways for a single residence. One of them is on Middle Road and one around the corner on Marjorie Street. And while the property across the street at 1 Sylvester Street has a single driveway, it is exceptionally wide and deep, allowing the residents to park boat trailers and multiple cars. If deemed necessary, we are willing to decrease the width of our existing driveway for the primary residence to approximately 20 feet, just to accommodate 2 cars side by side. Granting this variance for second driveway on a property which has substantial street frontage of approximately 277 feet will allow us the same reasonable use of land that has been permitted to our neighbors. And finally, we're also requesting relief from the 30-foot front yard setback requirement. Specifically, we are requesting the use of the front yard average per section 10.516.10 front yard exceptions for existing alignments to build a secondary dwelling at an 18-foot setback. Considering the existing primary residence at 2 Sylvester Street, our house has about a 0-foot setback. I think it might be 2 inches. The primary residence at 6 Sylvester Street has about a 6-foot setback, and the average of those would be 3 feet. We are asking for 18 feet. Given the dimensions of the proposed secondary dwelling, the required 30-foot rear yard setback, and the necessity for a second driveway, the shorter front setback and consequently a shorter driveway would result in smaller impervious surface area, which is beneficial in preventing drainage issues. The existing alignment of neighboring properties along Sylvester Street clearly establishes a pattern of reduced front yard setbacks, and constructing our proposed project with an 18-foot front setback would not be out of character with our neighborhood. The project, this proposed dwelling only faces the pool of the property in front of us, so it wouldn't like be directly obstructing someone else's house. And our design is specifically intended to be compatible with the existing streetscape and will not negatively impact the character of the area. We believe that the proposed use of our property is entirely reasonable, as it is zoned for residential and remains so. Our design allows for an appropriate utilization of our land without any adverse impact on the surrounding neighborhood. Applying a rigid interpretation of the zoning ordinance in a specific situation would create an unnecessary hardship, preventing us making reasonable use of our property in a manner consistent with what has been allowed to other properties on Sylvester Street and adjacent Marjorie Street. And we respectfully request that the board find this variance request fully complies with requirements of Article 2 and grant requested relief. Thank you for your time and consideration.
Thank you. Other questions? Yes, Mr. Ram.
Thank you, Madam Chair. So, per our staff report, just over 10 years ago, there was a request for this property to subdivide the lot into 2 lots, and this board voted to deny that petition. What effectively is the difference between what you're proposing and what was denied by this board 10 years ago?
I don't know what the person, we just bought the house last April, so I'm not sure what the plan was for those people. But again, we wanted to build an ADU, but with the size, it exceeds the size for the ADU. So we are going with a secondary dwelling per our meeting with the planning board. I guess we're not asking to subdivide the lot, actually. We're just asking to build a secondary dwelling. I'm not sure what the specifics are in terms of like subdivision, but we're not asking for that.
I think that's probably the next property over. But that wasn't, I don't think that was this property. I think that was.
Oh, no, you have like there was one here. Yeah, it was. They asked for it. It's okay.
So I guess that's a good segue to my next question is what you're asking for, as you've indicated, has a gross living area of 1,002 square feet.
Yes.
Yet you would be allowed to build the structure that you're looking for so long as you kept the accessory dwelling unit to 750 square feet per our current ordinance. That would still require a conditional use permit from the planning board, but that's a much less high bar to cross over. Essentially, it's allowed, but the planning board wants to review it, make sure it meets certain criteria.
Right.
What is it about that additional 252 square feet that is so important to you that you're taking this path?
I think just my husband is, it was like mostly his idea, the size of it, just to be comfortable as a living space. Like we've always lived in really small apartments and tiny houses, and even this house all the rooms are really small. So we feel that something this size is like much more comfortable to live in, as well as the 3 garages, one of which would be for our use.
If I may, Manager, my last question. So I would have to say in my 12 years, the first time I've ever had somebody bring up that they think that building a structure is going to somehow improve the acoustics in a certain area. I'm just curious, is that based off of anything scientific,
No,
or is
it's
that
like
just an impression?
if
that
you
have?
really like, I'm there outside with my son often, and he's 3 years old, and he'll like shout, and I hear like the sound just like bouncing off and coming back to me. So you can hear, it's just you can hear it. We live there, so like we can hear it. Sure. Our neighbors across the street have a pool. They have some parties. Like the sound just travels so much. It's kind of very, I don't know, it just somehow it creates like this little bowl, and the sound gets loud and echoes.
Sure, but in terms of this building that you're creating, somehow helping that situation, I mean, Are either of you acoustic engineers, or is there some
No.
technical basis for your assertion?
No, I just believe that having a structure there would kind of lessen this whole, with the lot being so empty, would lessen the sound traveling so much.
Okay, thank you.
It's just
And then
common sense. I
one
guess.
question for sort of combined staff, I guess. The applicant has indicated they believe that the averaging for the front yard is 3 feet, but the staff report indicates 0 feet. Again, probably not truly critical to this application. They're 18 feet away from the front property line, but I was just curious if you know.
Yeah, it was based on the front yard averaging section of the ordinance, and that is properties on the same side of the street within 200 feet of the property line, which I think reached only one property, if I can remember correctly, and
Okay.
that would be, it was 0, but.
Okay. Yeah, there was just a discrepancy between what the applicant is presenting and what staff has.
Yeah,
so
this is just based on our like measurements off of the map geo
Yeah.
tax map and the dimensions there.
Okay, thank you. Thank you, Madam Chair.
Other questions?
I do, oh, sorry.
Oh, Mr. Rossi.
My question is with regard to the driveways. What is the amount of space between, if I'm reading this correctly, and I just go by your property today, but now I'm trying to remember exactly how the driveway looked. The existing driveway, is this 30 and a half feet wide
Yes, currently, yes.
paved area?
Yes.
And then, without much space, you go to the 40-foot wide proposed new driveway.
Right.
What is that, like about a foot and a half or 2 feet? or
It
something?
might be like 2, maybe 3 feet or so
And what was your comment earlier? Were you saying that you would be open to?
to like narrowing our driveway if you're looking at it from, like standing in front of it from the right side where the proposed project will be, to narrow it down so that we could fit like just enough to fit our 2 cars, and then the rest would be, lawn.
What would that width be, in your opinion?
That would be probably, so like we'd narrow it by 10 feet to be 20 feet. So I would say probably 12, 13 feet or so between the 2 driveways.
Thank you.
Ms. Marchison?
Yes, so I want to go back to the hardship criteria. And again, I sympathize for your medical issues and your need or desire for additional income. So I don't want to overlook that, but the issue is that for the single residence B, only the criteria is 15,000 square lot, is 15,000. And yours is just over that, 15,798. And when you put 2 dwelling on it, that reduces it, as is said in the staff report, to 7,899. And that really brings it into the general residence A
Okay.
lot area that's allowed. But even in general residence A, we are not allowed to have more than 1 dwelling unit per lot. And the reason for that is to regulate density. And even though the other lots in the area may be sort of similar sizes to whatever the halves of your lot is, there still is only 1 dwelling unit on those lots. So what about the size of this lot says that the provisions of the zoning ordinance, keeping all that in mind, do not apply to this lot?
Well, I like based on the size that we would like to build, the right side, the left side of the property, the corner on Middle and Sylvester Street, like that's unusable because you have like the 2 front yards there. That whole area is like a pit that I guess some previous owners try to, excavate, blow up to build something that was not allowed. So you can't build on that area. On the other area, we have a 30-foot setback, 10-foot setback, so we only have like that small area where we can build something. And with the size, like I mentioned, of a comfortable living space, that's kind of like leaves us with the only place where we can build it.
Well, I think the placement is not what I was asking about. It's the fact that you are proposing to have 2 dwelling units on the lot, thereby reducing the lot area. This is a property that complies, except for the averaging, that complies with zoning.
Okay,
and this would take it out of compliance with zoning.
is that not why you were here for a variance?
Yes, yes. And so that's why I'm looking for a little bit more information on hardship, why this lot can't be used in compliance with the zoning.
I think the only way we could be in compliance, and I'm not even sure if we could be then, is if we made like a much smaller building, which I don't know, with 30-foot rear setback, and if we had to do a 30-foot front yard setback, that would leave us like less than 20 feet of like house size width. So that, does that answer your question? It gives us like a really small space to build something on. But we're not, we don't necessarily need all that lawn to have as a backyard. It's kind of, doesn't provide us any privacy at this point. Like I said, it's just like very open to the road. And yeah, we would like to put this project there, but that's why we're here for a variance.
Thank you.
Anybody else?
Just a question, I guess, based on Ms. Margison's question. It's really a question for staff. Is that accurate that the other lots adjacent and around it have only one unit? Because when I surveyed the neighborhood today, it certainly looked like there were outbuildings that were set up for dwelling.
Yeah, I mean, at least the property next door does have an ADU, a detached ADU.
Yeah,
And the property across the street as well.
that,
Yeah.
that's what I thought. Were you saying something different than that, Ms. Margison?
ADUs are allowed. Detached ADU is allowed
Right.
per the zoning ordinance under a cup.
This is too big to be an
This is
ADU.
2 dwelling units per lot.
Size and the height is too big.
I see. And the primary, what's the square footage of the primary structure?
720.
Oh, our proposed structure?
No, your current house.
Oh, the current house square footage total is like 13, it's about,
27.
no, square footage.
Oh, square footage.
It's about like 1,340
Okay.
or something like that.
I see. Thank you.
Any other questions, comments? Thank you. Is there anyone in the public who would like to speak in favor of this petition? Is there anyone in the public who would like to speak against this petition? Is there anyone who would like to speak to, for, or against?
Hi, I'm Taylor Andrews. I live at 1 Sylvester Street. I'm the pool party girl. I want to start by saying I don't enjoy this. I love my neighborhood. I love my neighbors, and I love Portsmouth for all it's become or becoming. Development has many positives. I'm not here to deny that. However, this particular proposal seems
Excuse me,
excessive.
could I ask you to slow down a little? I'm having a hard time understanding.
Sure.
And I'm sorry if
No,
this
it's
is-
okay. It seems excessive. I was here almost 2 years ago to the day for something similar in 2003, which the board voted against, and I thank you for that. This is not quite as invasive. However, there are some serious concerns that would never negatively impact my property in many different ways, potentially other surrounding properties, and contradicts many, if not all, the rules regarding variance requirements. First and foremost, my concern is with water flow and displacement. Over the 7 years I've been at 1 Sylvester, the increase in water is astounding. The residual effect of development, I'm sure, as we continue to watch our beautiful city grow, the cause and effect is undeniable. There's less and less area for water to harbor itself. It's not just costly in my electric bill and water sewer bill, but it's also directly affecting and compromising the structural integrity of my home. As the proposal itself states in section 4, steeply downhill from middle road surrounded by hills creates sort of a bowl. Those aren't just hills, they're ledge, and there's nothing to impede water flow from the street and wherever else it's coming from. So a bowl it certainly is, and it's filled with water. The bowl is compromised by our basement. So therefore, all of this water I am personally pumping out of my house all day, every day. My sump pump runs 24/7. There's flooding in our street often, and worse so the southwest side of my property is flooding all the time. My garage foundation has split, and even the flooring in my home has begun to undulate significantly. The footprint of this proposed structure, as well as the size of the driveway, create great concern for me as where is this water going to go? Also, creating all of this pavement area is not just a water concern, but doubling the pavement in the neighborhood, which drastically changes the current character. It turns a yard into pavement. Also, as mentioned, 4 Sylvester Street already has 2 driveways. With this plan, the entire left side of the street is just going to be a large parking lot. It being a narrow dead-end street, I don't think I have to explain further why that would affect everyone. And certainly my driveway, my yard, and traffic flow for the street as a whole. They spoke about privacy for themselves. Well, you know, a garage with a home above it, kind of, you know, just kind of like overlooking is. Anyway, diminished value is also on the table, where it's impossible to predict what buyers prefer, a home with a yard or tightly compacted with no yard. But if we refer to the building proposal by going off the placement of the structure, it seems considerable measures were taken for the second dwelling unit to be closer to the neighboring property as opposed to their own, which would indicate the value of open space was taken into consideration for their property as their primary dwelling unit. To be honest, there's a lot I'm concerned with. 5 minutes isn't enough, and as I said, this is not an ideal position for a neighbor to be in. I'm not opposing development. I guess I'm just hoping for some consideration of the larger picture. Also, the thing about the driveway is my neighbor, 3 Sylvester Street, they have not 2 driveways, but it's a half circle. It's because it's like a dead-end street, and their driveway's for their personal use alone. My driveway is long because it leads to my garage, for lack of a better term, as it can't hold a car. So consideration of the larger picture, some understanding of what makes our neighborhood so desirable, and potentially the realization of the magnitude of the structure and how it can negatively affect so many things. I can surely side with them on all the personal reasons they've listed, even though the current garage on their property did house their neighbors' cars. Who wouldn't want a bigger garage? I dream of a usable garage regularly. I'm also sincerely aware of the cost of living and owning a home. Most months I'm barely keeping my head above water paying my own mortgage, so I wholeheartedly understand the desire for rentable space. However, it's hard to foresee how the cost of building a structure of this magnitude would supplement its expenses. And not just that, but please consider the residual expenses that would fall onto me and other neighbors, whether it's directly affecting the value of my home or the quality of living that I currently have, and this street in particular does provide. The value of property is in rarity and uniqueness, and Sylvester Street stands to lose that with this particular plan.
Okay, thank you. Is there anyone else who would like to speak to, for, or against?
Is anyone listening?
I want to remind you, though, that in front of you, there was a letter. The first page of the packet and the last page. This public hearing is closed. There is no one? Oops. Okay, there is nobody. So, yes.
Thank you, Madam Chair. I'll start off with some discussion. So in my mind, this application comes down to 252 square feet. The applicant, as I asked, by right, with all the other things, they have a plan for a structure that meets setback requirements. It is within the total amount of allowable coverage for their property. The biggest issue that they have is they wish to build a livable footprint of 1,002 square feet, where our ordinance allows a maximum of 750 square feet for a detached accessory dwelling unit. In my mind, they could build this thing, but they could just build a ADU that meets that requirement. Yes, they would still have to go before the planning board, but again, the conditional use permit process is a much lower threshold for approval than it is for a variance. In this case here, the variance, first of all, in essence, a prior owner, admittedly not these individuals, but a prior owner came before this board back about 10 years ago looking to do essentially the same thing, but by doing a subdivision rather than asking for a second dwelling unit and a second structure. This board voted to deny it at that point in time. I think that the reasons for doing that are still in place. As Ms. Margerson has pointed out, this is currently, from a zoning standpoint, a fully compliant lot. And the request that's being put here would essentially cut that in half. And, you know, it's requesting us to allow it to be half of what the requirement is for this zone. And I still have yet to hear anything from a hardship standpoint that indicates that those 252 square feet of living area somehow translate into a relatively high bar with a variance request of allowing that to happen. So, I mean, I think there's a path forward here for the applicant. I think that the path through trying to get a variance for trying to achieve their goals is too high of a bar, that they have not demonstrated sufficiently that the criteria are being met, particularly for hardship. In this case, again, they're really going up against two separate buildings are not allowed at all, except as a potential for a detached accessory dwelling unit, which there's legislation for, and it's incorporated into our ordinance. So with that, I don't think that they're meeting our bar, and I cannot agree to approve what they're requesting.
Yes, Mr. Mattson.
Yeah, I'll just make some comments that are neutral. Is that so we had this situation before where on the same side of Sylvester Street, when they were seeking to receive a variance, this neighborhood is interesting because there are multiple lots that are quite small and would not be allowed by right today. But there are also other larger lots that are similar to the size of this lot. So I guess the only thing I would add is that we can see it from both sides is that the logic for not subdividing, but ending up with two structures on the same property would be similar to the density on Marjorie Street. But again, like on Sylvester Street, across the street, that's also the same size lot with one dwelling. So I guess I could see it going either way.
Thank you.
Super helpful.
Thank you, Mr. Mattson.
Yes.
Yeah, I struggle with this one, too.
Me too.
The September 2014 issue that was raised at the city council was that these lots either were voluntarily or involuntarily merged, and the record was not clear. So at one time, this was probably two or I think actually three lots that somehow got merged, and the city council didn't. There was a difference of opinion about whether they were involuntarily merged or voluntarily merged.
And there was history that they were voluntarily merged.
Yeah. And so, you know, the city council didn't do it. So then they came back for the variance to the board, and the board denied the variance. And as Mr. Ram pointed out, this is essentially the same thing.
Yeah.
To put two residences on a lot where they will not meet the zoning requirements. I mean, kind of like Mr. Mattson, it's kind of a neutral comment. I'm not expressing an opinion one way or another. It's just the history here is so convoluted.
It is. This is not easy.
Well, I will revert to general principle, and there are a couple of things that bother me, and I think Mr. Rayum maybe got both of them, but I'm not quite sure. One is that we're taking a lot that and a structure that is dimensionally conforming and making this a non-conforming lot, which we don't really need to do. So I, on principle, don't agree with that. I also think that we see a lot of pressure to put multiple dwelling structures on a single lot in residentially zoned areas, and we generally turn those kinds of variances down. So it would be unusual for us to allow that to happen. So I'm not going to support the variance, especially since there's another option to them with the accessory dwelling unit.
Would someone like to make a motion?
I will make a motion to deny the application as presented and advertised.
Is there a second?
I'll second.
Okay, thank you.
So in order for an application to fail, it really only needs to fail on one count of the variance criteria. And I'm going to focus on the hardship criterion. In order for this to pass the hardship criterion, there would have to be something unique about the nature of this lot that would, militate that this is the only way to proceed for all practical purposes. And there is no mitigating characteristic of the lot that says this is, this particular structure has to be located at this size in this place in order to achieve the goals of a reasonable use of the property. And I'm looking at reasonable use in this case as having an additional dwelling unit, which can be accomplished within the context of our existing ordinance for accessory dwelling units. So just to summarize, there is no special characteristic of the property that I see that means that it cannot be used in a reasonable and conforming manner.
Ms. Murchison?
So my second is that the zoning ordinance is very clear that there can only be one lot per dwelling unit, and that's in the single residence A or B, general residence A or B, rural districts. It's very clear that that is what the ordinance commands. And the only way we can deviate from that is if the property does have special conditions. And I do not find also that this property has special conditions. I say that with sympathy to the applicants, but to regulate density, we have to have one dwelling unit per lot. And also, this is a perfectly conforming lot to the zoning ordinance. And I see that there is nothing that militates against deviating from the requirements of the ordinance.
Okay. Does anybody
They
have
have not
any-
demonstrated hardship.
sorry.
Sorry, I should have been more succinct. They have not demonstrated hardship.
Is there anything that anyone would like to add before we vote? Ms. Janice?
I think it doesn't, excuse me, I don't think this request is consistent with the spirit of the ordinance. In addition to the issue of one dwelling unit per lot, the ordinance is designed in this area for 1 to 3 residences per acre. This is effectively saying more than that, I think somewhere around 5. Now, I note that there are other properties around that are on smaller lots which don't comply either. However, our ordinance specifically says that those aren't supposed to be used to justify the spirit of the ordinance. So I think that's another reason why it does not comply. Should not be granted.
Mr. Mann?
Yeah, thank you, Madam Chair. I will be supporting the motion, and I actually was going to bring up what Mr. Neese just did. But the other part is, I mean, it's recognized that we need additional housing. There is a relief valve for that in terms of the accessory dwelling unit. Currently, per state statute, as adopted by the city through its ordinance, 750 square feet is the maximum that's allowed for that. I mean, there's some legislation that's bouncing around in Concord that may change that number to increase it. But I think it's been reflected that that is a suitable size of dwelling space that is conducive towards meeting the fundamental goals of adding to the housing in a way that is not overly burdensome in single-family neighborhoods of the surrounding properties, but still is, advancing our overall goal of trying to increase the number of dwelling spaces. So I think there is a relief valve here. And I think that, that is something that could be taken advantage of, but what's being asked for here is just simply beyond what we can meet with our bar for a variance.
Yeah, I just wanted to add on to that is, yeah, basically, I think this is a pretty compelling case, but my fellow board members have provided some very rational points that make it hard to support, but I guess I would hope pursuing an accessory dwelling unit would be a feasible option here because of the need for additional housing and that relief valve.
Okay, thank you. All right, so a yes vote denies the project. Mr. Neese?
Yes.
Mr. Mannel?
Yes.
Ms. Margerson?
Yes.
Mr. Ram?
Yes.
Mr. Rossi?
Yes.
Mr. Mattson?
Yes.
And the chair votes yes, so you are denied. Okay, now we have this monster one. Okay, item C will take me about 20 minutes to read, so be patient. Yes, we'll take a quick,
I know it's normally
Yes.
9 o'clock, but I didn't know if we could do it.
Yeah.
over the-
would you like a little quick break?
If it's
I would be
possible, I'll
happy to
manage
do that. Will you give us 7 minutes?
Absolutely.
Okay.
Cat.
We don't have Mr. Mattson.
Okay. Oh, we don't,
wait for
sorry.
Jeffrey.
We don't have Mr. Mattson. Okay, we'll wait. Okay. The zoning board meeting for April 22nd, 2025 is back in session, but I have to read this into, before you can. Item C, the request of Colbia Enterprises LLC for property located at 1980 Woodbury Avenue. Whereas relief is needed to demolish and redevelop an existing gas station and convenience store, which requires the following. 1, special exception from section 10.440, use number 8.122 to allow a convenience goods to use with 24-hour per day operation. 2, variance from section 10.5B33.20 to allow for a front lot line build-out of 0% where a minimum of 75% is required for a commercial building. 3, variance from section 10.5B34.60 to allow for a front setback from the lot line of 27 feet on Woodbury Avenue and 46 feet on Gosling Road, where a maximum of 20 feet is required. 4, variance from section 10.5B83.10 to allow for parking spaces to be located between the principal building and the street. 5, variance from section 10.835.32 to allow for drive-through lanes, bypass lanes, and stacking lanes to be located within 13 feet of the property line, where 30 feet is required. 6, variance from section 10.835.31 to allow outdoor service facilities to be located within 38 feet of a lot line, where 50 feet is required. 7, variance from section 10.843.33 to allow for pump islands to be located within 28 feet of the lot lines, where 40 feet is required. 8, variance from section 10.1251.10 to allow for an aggregate sign area of 454 square feet, where a maximum of 223.5 square feet is allowed. 9, variance from section 10.1251.20 to allow a 134 square foot freestanding sign, where a maximum of 100 square feet is allowed. 10, variance from section 10.1253.10 to allow for a freestanding sign at A, a height of 26.5 feet where a maximum of 20 feet is allowed, and B, 2 freestanding signs at a setback of 3 feet where 10 is required. And 11, variance from section 1252.40 to allow illumination of a gas pump canopy area that shall not be included in the sign area, where it is distinguished from the background only by color stripes. Said property is located on Assessment Map 239, Lot 11, and lies within the Gateway Corridor District. Is there anyone to speak to this petition?
Yes, thank you to the Honorable Board. My name is Christopher Drescher. I'm the attorney for the applicant. I think we have some, that last variance for the illumination, that was removed. We're not
That was
asking.
removed?
Yeah, we're not asking for that
Okay, it
tonight.
was not removed for us.
Okay, no problem. I know we went back and forth with staff a couple of times, making sure we got all our
Okay, so
I's
no,
dotted and T's
no
crossed.
illuminated with the stripe, okay. got it.
Correct, thank you. And I guess just logistically, before I start about that 15 minutes, I'll do my best here, but we got quite a few to get through. Unless I'll do my best to consolidate these variances, there's a lot of repetition.
Okay, because
No.
if you don't ask first, we're going to cut you
All right.
What's the maximum amount of additional time you can
15.
have?
What's it, well, what he asked for, and we decide if we want to give it.
What specifically is it?
Usually ask 10.
10 extra minutes, I think I could probably plow through it. There's a lot of repetition, and I'll try to mull over that when I can.
Okay, so you don't want the 10?
Yes, please, the extra 10 minutes would be great.
So
just
there's
to
been
be
a
safe.
request for 10 minutes. Would someone like to move to allow that?
Madam Chair, I'll make a motion to allow the applicant an additional 10 minutes. If we're watching them very carefully. There is a lot here, as you already indicated. There's
Yes.
a lot of relief that's being asked for. I would like to make sure that the applicant can fully explain that. Although their written word was certainly very, 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 very lengthy. Hopefully that they can be a little bit more concise in their spoken word. So,
Okay,
but I would move to give them the
Is
additional
there
time.
a second?
Second.
Okay, all in favor?
Aye.
Opposed?
That is-
Nobody. Okay.
It is my goal to try to not use the 10 if I can.
go.
We have here for you a variance plan. If Jason, if you've handed it out, this is the variance plan. I think this will be the easiest visual tool to follow along. Again, my name is Christopher Drescher. I'm the attorney for the applicant. With me tonight is Chris Rice and Jason Cook of TF Moran. They're the engineers who designed this plan, as well as behind them is Jay Hall, who's in-house counsel for Colbia Enterprises LLC. Just an overview of the project as a whole. The applicant is the owner of 1980 Woodbury Avenue in Portsmouth, which is sometimes referred to as tax map 239, lot number 11. Property is zoned in the Gateway Corridor G1 Mixed Residential District and sits right on the border of Portsmouth and Newington, New Hampshire. The property is currently developed with a mobile fueling station and / convenience store that is leased by the applicant. The applicant intends to take the property back from the lessee and construct its own fueling station under its in-house brand known as Seasons Corner Market. The applicant, for what it's worth, is a family-owned company that retains and maintains its businesses as opposed to selling them off once they go through the permitting process. They operate many facilities in New Hampshire, some in Nashua, Hooksett, and Tilton, and they have some 55-plus sites throughout New England. The property is currently surrounded by almost entirely commercial businesses, with the one exception of a residential multifamily housing development, which does sit in the same zone and directly abuts the site to the east off of Gosling Road. There is currently a large wooden fence as well as a chain link fence and some vegetative buffering already between those two lots. Property is a corner lot with ingress and egress along both Gosling as well as Woodbury. And the current mobile fueling station has a convenience store and a large canopy that extends out on both sides of the store. And there are 8 fueling islands with a total of 12 fuel pumps. What the applicant intends to do when they renovate this property is reduce the scope of that canopy as well as reduce the number of fueling pumps down to 4 islands with a total of 8 pumps. And additionally, the convenience store will be oriented to be flush against and presenting to Woodbury Avenue. Currently, the one entrance for mobile, I think, faces Woodbury, but is obscured by that large canopy. The applicant intends to have a drive-through lane, which will be relative to a co-brand business. For example, Heavenly Donuts, Mary Lou's Coffee, Honeydew Donuts would be sort of a counter, go up, order the food, walk away. And that would be subordinate to the store and the fueling uses. According to a quick registry search, the property was conveyed from the previous owner, which was Duncan Construction Company, in 2010 to Greenback Security LLC, and we cited to the registry for that the site in our pleadings. Prior to that 2010 conveyance, the property was owned by Duncan Construction Company since October 22nd of 1958, according to the very same deed. That deed appears to be too old to view online. Now, Portsmouth adopted its zoning in 1926. And while this property may have been conforming at one time, I don't know for sure, the lot is certainly not conforming under today's standards, which is readily evident by all the dimensional relief that we're going to be needing to ask for here tonight to replace one fueling station with a convenience store with another fueling station with a convenience store. So having said that, I think I'll move into the special exception. We do need a special exception to have that convenience store be a C2 convenience store under your zoning ordinance. The special exception criteria is found at section 10.232.20 for the record, and they have to meet the following standards. 10.232.21, standards as provided by this ordinance for a particular use permitted by special exception. The proposed use requires a special exception for the convenience store to collectively be part of this fueling station. Convenience stores are quite commonly attached to fueling stations. The use of the fueling station is an otherwise allowed use by right. Across Gosling's Roads, it's notable to say that there is a Cumberland Farms there in Newington. I understand it's a different town, but it's right across the street there. Same thing, convenience store, gas station. So what is being proposed is certainly consistent with the surrounding area. And the existing business at the property is a fueling station already with a convenience store. So what is also being proposed is consistent with what is currently going on the property. Section 10.232.22, no hazard to the public or adjacent property on account of a potential fire, explosion, or release of toxic materials. Well, the convenience store certainly doesn't pose any immediate threat of fire, explosives, or toxins, nor is the proposed convenience store a threat to the public or the adjacent properties. The adjacent properties, again, are largely commercial. Some are even fueling stations with their own convenience stores. I noticed that there were some down the street when I took a drive-by today. There are other stores in the area that have drive-through components. Right next door we have a Dunkin' Donuts. To the extent that the fueling station's gasoline may have a potential fire, explosive, or toxic issue, well, I'll say this, that the applicant intends to use the state-of-the-art protections to measure for public safety, and regardless, a special exception is not needed to have the gas. Section 10.232.23, no detriment to the property values in the vicinity or change in the essential characteristics of any area, including residential neighborhoods or business and industrial districts on account of the location or scale of buildings and other structures, parking areas, accessways, odor, smoke, gas, dust, or other pollutants, noise, glare, heat, vibration, or unsightly outdoor storage of equipment, vehicles, or other materials. The proposed use is a commercial use that is otherwise permitted in the zone. There is already a fueling station with a convenience store on site, and additionally, there is the aforesaid Cumberland Farms there right across the street that is a very similar business. Thus, the essential characteristics of the neighborhood will remain unchanged. The proposed use, even though we have to be here to ask for a special exception, is consistent with the surrounding area. Furthermore, what is being proposed will be an improvement. We're going to give this place a nice facelift. The existing fueling station is working with outdated equipment. We're going to upgrade all that to state-of-the-art equipment. The proposal will aid in the property values. If anything, it won't be detrimental to them. There's certainly not going to be any outdoor storage of equipment or vehicles. There will not be any odor, gas, smoke, or dust, or other pollutants, certainly not from the convenience store. And I will say this about the noise level. It's certainly not going to be any different than what's there today. Section 10.232.24, no creation of traffic safety hazard or substantial increase in the level of traffic congestion within the vicinity. It's a gas station. It's at a major intersection. Obviously, there's going to be traffic. It's well designed to have the in and out. We have good egress. We have good ingress. I think we have 3 curb cuts, all of which we're going to be upgrading. Much like the noise, the comment on the noise, we're certainly not going to add any more traffic than is already going on. So section 10.232.25, no excessive demand on municipal services, including but not limited to water, sewer, waste disposal, police, fire protection, and schools. Well, certainly we're not going to do anything to the schools. What is being proposed is replacing one fueling station with a convenience store, again, with another fueling station with a convenience store. The proposed project will be reducing the number of pumps as well as reducing the number of stations. So we would contend that this proposal may result in reducing such demands, but it certainly is not going to add further strain upon any of your municipal services. And finally, no increase, section 10.232.26, no significant increase of stormwater runoff onto adjacent properties or streets. We have top-of-the-line engineers here from TF Moran who've designed this. They'll be sure to make sure that we're not going to have any stormwater issues. And that is what I have for the special exception. Madam Chair, you want me to just plow on through the variances?
Yes.
All right.
Please.
Variance number 1. This is from section 10.5B33.20. This is to allow a front lot line build out of 0 feet where a minimum of 127.5 feet would be required as the 75% build out that the ordinance requires for commercial and mixed-use buildings. However, this proposed project, at least the building, the store itself, is set back beyond the 20-foot setback from the provisions for this to apply. So we're not going to be up in the front of the lot. Therefore, we're asking for 0 feet. Granting the variance will not be contrary to public interest. I'm sure, as this board is very familiar with, the legal standard here is whether granting the variance will alter the essential character of the neighborhood or negatively impact the surrounding areas with respect to health, welfare, or safety. Always important, I like to note that this is in the negative. So it's not to say we have to prove something's in the public interest, just that it's not contrary to public interest. Here, the immediate ask is to allow that front lot line build out to be 0 feet where otherwise would be 127.5 feet. The lot is small, it's pre-existing, and given that the fuel pumps, you've got drive-through lanes, the store is going to have to be placed in the middle of the lot. It's the only place that makes any sense to put this on this small non-conforming lot. The reason, there's no reason to have the store closer to the front line of the property, and to do so would not really make sense for a convenience store gas station. The property has historically been used as a fueling station, and despite the need for a special exception, the convenience store is otherwise allowed use, assuming that you grant that special exception. This relief would be required for any similar convenience store or fueling use to be on the lot. In fact, I would say that what's on there now is not conforming with this. So consequently, given that we're replacing the convenience store gas station with another convenience store gas station, I think it's safe to say we're not altering the essential character of the neighborhood. It is still very much a commercial. It's still going to be a gas station. And given that we're minimizing the scope of this operation compared to what's on there, I think it's safe to say that we would not be negatively impacting the health, safety, and welfare. And there's simply no evidence to point to that I can think of that would suggest otherwise. As for prong 2, spirit of the ordinance, it's the same analysis as prong 1, as per the New Hampshire Supreme Court. And then number 3, granting the variance would do substantial justice. Well, I think you all know the standard. I've heard you say it here tonight already, that a loss to the individual that is not outweighed by a gain to the general public is an injustice. Here, what the applicant is attempting to do is improve this property, make it better, make the operation smaller. If denied, the public doesn't really stand to gain anything, because what they intend to do will be an improvement. Surrounding value properties, prong number 4. Again, we're replacing a gas station with a gas station, a convenience store with a convenience store, and what we're going to be doing is upgrading it, making it nicer. We're going to be giving it a nice facelift. Again, as I said, the applicant retains control of these properties, does not turn around and sell them. They're going to be maintaining it. So there's really no evidence to suggest it's going to negatively impact the surrounding property values. If anything, we might be doing some justice in enhancing them. And finally, hardship, 3-step analysis, special exception, fair and substantial relationship, and is the use reasonable? Special conditions. It's a small property. It's non-conforming. The use that we're asking for has historically existed there for decades. Property is a corner lot. It's well suited for the in and out traffic that's associated with gas stations and convenience stores. And while what we're proposing is going to be reducing at least the fueling operation by 50%, and to the extent that any residential areas would be impacted, we would contend that there's some adequate screening already existing along the edge of the property there, as I mentioned earlier. So the fair and substantial prong, as I always like to say in plain English, if you grant the variance, will it unreasonably frustrate the purpose of your ordinance? Well, the purpose of this ordinance is aesthetics, overcrowding, life and safety. More specifically, I would assume that the city of Portsmouth wants to control the size of the buildings along that front lot line and have them flush against the road for aesthetics. That just doesn't make sense for a gas station and convenience store. You have to have it pushed back and have the cars pull in and pull up in front. It's not a historic building or anything like that. And so overall, we contend that if the relief is granted, it's not going to unreasonably frustrate your purpose. And the use is a commercial use, which is otherwise allowed, so the use is reasonable. Variance number 2, which is from section 10.5B 34.60. This is to allow the front setback of the lot line of 27.4 feet, where a maximum of 20 feet is required. This is where the building's being set back, the store is going to be set back beyond that 20 feet. Not contrary to public interest. Again, there's already I'll just try to summarize here, because I don't need to go through the legal standard, as I know this honorable board knows it well. But I'll just say this ask is minimal. The lot is small, it's pre-existing. There will be fuel pumps and drive-through lanes. The store has to be placed in the middle of the lot. It's the only place that makes sense, and certainly from a life and safety point as well. There's no reason to have the store closer to the front line. The property has been historically used as a fueling station and a gas station for decades. This relief would be required, frankly, for anybody coming to you to try to do anything on this lot, given its dimensional constraints. So given that, again, gas station for gas station, we're not altering the essential character of the neighborhood, and we think we'll actually be improving the safety of the area. And there's no evidence to suggest that the public would be at risk. Prong 2, same analysis as prong 1. Prong 3, substantial justice. Once again, a loss to the applicant is always great. Is there going to be a gain to the public if it's denied? Not when we're considering the fact that we're improving what's going to be there. Number 4, surrounding property values. Again, we're improving the place. There's no evidence to suggest that the surrounding properties would be negatively impacted. And finally, hardship. Once again, small size. The use is historically used for a gas station convenience store. The property is a corner lot. It's well suited. What we're proposing is a reduction in the operation to the extent that any residences would be impacted. There's already adequate screening in place. It's very similar. Again, we've got similar properties going on around, like the Cumberland Farms across the street. But again, so that fair and substantial prong, again, unreasonably frustrating the purpose of your ordinance. Setbacks are for safety. Setbacks are for aesthetics. Here we're asking to go beyond that 20 feet, really for safety reasons. We want to put that building in the middle of the lot so that the pumps are out front, but they're still set back enough from the road. It just makes more sense. Again, it's not a historic building or anything like that, and we contend that the use is reasonable. It's a commercial use in a commercial zone. Variance number 3, from section 10.5B, 83.10. This is to allow for parking spaces to be located between the principal building and the street. Not contrary to public interest, it doesn't make any sense. If you're going to pull into a gas station, you pull up to the store. I would presume that the reason you would have this would be so that people would drive around back behind a commercial business. But for gas stations, it doesn't really make sense because when people pull in, they go right to the pumps. We contend that, again, the lot's small. This ask is minimal. There's going to be fuel pumps, drive-through lanes. The store has to be in the middle of the lot. There's no reason to bring the store closer to the front line and consume up those parking spaces. This is a use that has been on there historically for decades. It certainly is to the best of our knowledge, has been any issue with the parking spaces the way they're configured now, but they're certainly in violation of your ordinance as is at the moment. But again, we don't contend that this would alter the essential character of the neighborhood, and we think that the improvements that they're going to be made are going to be better for life and safety. Prong 2, same analysis as prong 1. Prong 3, substantial justice. Again, what we're doing is trying to make the place nicer. We're trying to make it better so the public doesn't stand to gain anything if we're denied. They'll be stuck with what's there now. Surrounding property values, again, what we're doing is enhancing it. So we would contend that we'll be adding to those property values. And again, hardship. Again, those special conditions. It's been historically used as a gas station for decades. It's already non-conforming. It's well suited, and to have it in the middle and have the parking spots where we're suggesting it to be is the most effective and safest for the traffic flow. Again, we're reducing the amount of the fueling operation. So again, we would contend that this is not really unreasonably frustrating your ordinance if this relief was granting. Encouraging parking behind commercial businesses, I can understand that, but not for a gas station. And again, it's a reasonable use, as it is a commercial use. Variance number 4, section 10.835.31. This is to allow the outdoor service facilities. Okay, this is for the transaction windows, the menu boards, those speakers when you drive up to go through a drive-through. They're required to be set back 50 feet from the lot line, and here we're asking them to be set back 35 feet. So contrary to public interest, again, the neighborhood already has commercial businesses. It has drive-throughs. It has gas stations. It has convenience store. We're not going to be altering the essential character of the neighborhood. And to the extent that this setback is being encroached on, we do have a buffer that is along that borderline. We've got two fences, wooden chain link fence, I believe, as well as some vegetative buffering. I learned here this evening that the equipment that they're going to be using for this is state-of-the-art and is not as loud as some of the older speakers for these drive-throughs are. And to the best of our ability, we've sort of stuck this stuff, down in that sort of bottom left, if you're looking at that picture, part of the lot, which I guess is as far away from all the other action that's going on as we could get, given the dimensional constraints of the lot. But again, we're not altering the essential character of the neighborhood. There's drive-throughs all over the place. And again, with the upgrades that we'll be making, we would say that we'd be fostering the welfare and safety of the surrounding area. Spirit of the ordinance, same analysis as number one. Substantial justice, once again. If denied, the public gains nothing, as what we're trying to do is improving it. Surrounding property values, again, we're improving it. We'll be enhancing the property values. And finally, hardship. I mean, I've already listed all these same conditions. I mean, this is a setback for the drive-through. As you can see, given the size constraints of this lot, there's not much we have to work with. I mean, we're here putting a project like this on this lot. We're here asking for something, no matter which way you slice it. But we would contend that we're doing the best we can with it. And at 35 feet, I would say that we're not unreasonably frustrating the purpose of that ordinance. And like I said, we've gone on record saying we're using the state-of-the-art equipment. We're going to try not to be too loud and bug the neighbors. And again, most of the neighbors are commercial businesses. Reasonable use, it's commercial use, it's reasonable. Number 5, section 10.835.32. This is to allow for the drive-through lanes, bypass lanes, and stacking lanes, we'll just collectively call them the drive-through lanes, to come within 13 feet of the required 30-foot setback from the lot lines. This is sort of a cousin of the one I just went through. It's basically the throughways that are associated with that equipment. So again, prong number one, contrary to public interest. We're not changing the essential character of the neighborhood. There's businesses like this all over the place. Given the improvements that we're going to be making, we will be enhancing the public interest and the safety. And we think what we've done by sending the traffic around back, that's probably the safest route that we could do in the interest of life and safety. So again, prong 2, same analysis. Prong 3, substantial justice. Once again, we're improving the place. So if it's denied, we won't be able to improve it, and the public stands to gain nothing. Property values, again, we're improving the place, so I would say that we're fostering property values. An unnecessary hardship, once again, it speaks to the nonconformity of this lot. Yes?
You have about 3 minutes.
Okay. It has to do with the nonconformity of the lot. That's the only place we're going to be able to put it, so it kind of has to go there. Is the Reese usable? Yes, it's a commercial use. Next variance is 10.843.33. This is to allow the fuel pumps to come within 28 feet of the 40-foot setback. I'll be very abbreviated on this one. There's no other place to put these pumps, I think, and stay within that setback, so that's kind of where they have to go. But like I've said, right now, we are shrinking those pumps and making it a smaller operation. So for that point, we're not changing the essential character of the neighborhood. We're fostering safety. I've said everything I need to say about prongs 2, 3, and 4. I'm not going to repeat that. Hardship, once again, it's the dimensional constraints. We have to put them there. Is the use reasonable? Yes, it's commercial use. Next, we have the aggregate sign areas. I can probably just sort of lump all the signs into one pitch, all right, even though there's different ones. And for the record, 10.1251.10, this has to do with the lineage of the feet. Sections 10.1251.20, maximum sign area. We're asking for a little more on that. And 10.1253.10 to allow a height, a little more of a height. Very plainly, this is the standard sign that Seasons Market uses. We have several businesses. We have the gas. We have the co-brand. We have Seasons Market itself. The drive-through, all these things. So the signage, we got a lot to cram on one sign. That's why we're asking for the extra little size. I will say when I took a drive around the area, there's a lot of large signs over there. A lot of them look like they probably don't conform to these sections of the ordinance. And obviously, the one across the street is in a different town. That sign is massive. But I'll simply say to that effect, we're asking for that so that we can get all these things onto one sign so that folks can find out where they are. It's a commercial area. It's not changing the character of the neighborhood. The signage is sort of fosters safety. And once again, it's sort of the dimensional constraints and the nature of the neighborhood that we're asking for this relief. And is the use reasonable? Yes, it's all part of a commercial use, and that is the best I can do in trying to get this done in time. Thank you.
Good job. Are there questions for the
The
applicant?
engineer's here if you have any questions.
Yes, Mr. Ray.
Thank you, Madam Chair. So starting with the special exception, I guess I want to understand what the current use is. So really, convenience goods 1 versus convenience goods 2. The distinction is food made
I think it's
on site.
Yeah, it's the business inside there. The co-brand, I think, was what bumped it up to C2.
Right. So your argument in your written word, and I think you reiterated it in some of your discussion, is that the current use is a convenience goods to store. I know there's a Moe's on site. I'm not a big fan of Moe's. I know that's heretical in Portsmouth, but I'm not. But I'm just curious, what is the current use by your lessee or your client's lessee in terms of meeting that? And what is your proposal? How does your proposal different from what they're currently doing?
Yeah, actually, Jay, I might need you on this one. So what do I didn't go into the mobile? What do they have going on in there? Sure. Yeah, Jay Hall, the counsel for Colbia.
James Hall, counsel for Colbia. What you just said. There's a limited food offering in the station now with our tenant. It would be not as robust as what we would be doing. We would be doing more fresh food. They still offer some fresh food, prepackaged food, but in terms of the similarities of use, it's a similar use. Ours would be geared a little bit more towards fresh food.
Okay, but they are currently preparing foods on site
Not on
for
site.
sale.
They're prepackaged foods, so this would differ. That's where you go from 1 to 2.
Okay, because the written word indicates that your argument is you're currently a convenience goods to store, and you're proposing to do the same, but you're implying that they're probably more like a convenience good 1 store currently.
Yeah, technically, I think there are 2 because they have roller grills and you can get hot dogs and things like that. But
okay,
that's a bit of a technicality, and I don't want to be disingenuous. Our proposal would be for fresh sandwiches made on site, which is probably more of a closer or more in line with the convenience too.
Okay, and then the drive-through portion of this, is that also tied to the ability to provide foods that are made on premises to people who are coming through?
Correct.
Okay, and I think there was some discussion, and I think it's also in the written word of it being a 24-hour. I know certainly the gas station portion is 24 hours. What is the intent with the drive-through in particular? Is the expectation that that would be an operation 24 hours a day?
No, it is not. We don't have it. In none of our we have our own brand called Seasons Corner Market Cafe. We wouldn't operate that as a 24-hour store. Even in stores that we have at Dunkin' Donuts, we don't operate the drive-through for 24 hours. Very often they're either, depending on the municipality, 6 a.m., 10 a.m. Sometimes you'll see them from 5 to 8. It would depend on the demand at the time, but there's no interest in opening the drive-through for 24 hours a day.
Okay, so would you have, if this board wanted to make a stipulation on that time frame, would you have a time frame that your client would be amenable to? Or could develop one?
Yeah, I fine with that. You could do 5 to 10. It may end up being 6 to 10, or it may be 5 to 9, but that's a stipulation that it's not a 24-hour drive-through is certainly acceptable. We don't have any interest in doing that.
Okay. And then in particular, this may go to somebody else on the team, but so again, with this drive-through, certainly per your written word, your argument is kind of, hey, there's a Dunkin' that's a couple doors down that has a drive-through, so we want to drive through too, and it's kind of okay. I know that some of the spoken word here tonight was, well, it's all commercial with one residential, but residential is pretty important. It's a fully developed area. There is a building that's just on the other side of the fence from your client's property. I'm trying to understand I know you talked about, hey, we have the most modern equipment, et cetera. I guess I'm looking for, has a more detailed analysis been done, or is it something that could be provided that would say, no kidding, if we really put this, because it's really, okay, that part of it is people talking back and forth, which is certainly very disconcerting to people in a neighboring residential area, but it's also cars idling, people leaving their phone, having phone conversations, radio, et cetera, all in a very close proximity. There's a reason why we request the 50 feet. So I'm just curious, has been any analysis really been done on what you think the potential impact to that residential area that's just on the other side of, I know you said it's a fence and some screening, but what would be the impact to that by the fact that you're moving this closer to that property line?
In terms of the sound decibels at this particular location, no. We have studied it at other locations, and we can, it's state of the art. I mean, these are drive-through systems, but, back in the day, you couldn't turn them down. We have the ability to turn them down. We have the ability to make sure that the volume coming from the machine is not resonating off of the property line. Right now, as it stands, the way the orientation of the pumps are, those pumps that are currently there and the cars coming through to fuel at the stations that are closest to that property line, they'd be much closer to the property line. They're currently coming through there, stopping, radios on, fueling, talking, that type of thing. My experience, now I haven't done a particular study at this location, is the use of the drive-through or idling through a drive-through is quieter than the use at the pumps. The pumps generally are out in front. They tend to issue a bit more noise, if you will, in terms of cars and alarms and, people talking and radios on and that type of thing. But again, state of the art, you can turn down the volume on the thing so you're not pushing decibels over the line that would be in prohibition.
Okay. If I may continue, Madam Chair. And then, so in terms overall of, much of this relief, there was discussion in the write-up, there's discussion that was presented here tonight, basically, hey, if it's going to be a gas station, it's kind of got to be this way. And I do appreciate that you provided photos of some of the other gas stations that your client has in New Hampshire, and apparently they also have a number throughout New England. I mean, what I see is that you're proposing to put a copy of what's done everywhere. It's what your client wants to do, and put it into our ordinance, whether it fits or doesn't fit. So, and I'm doing this just to give you my current perspective, and I want to give you an opportunity to sort of change my mind on this. So our gateway district has been set up quite deliberately, and you kind of hinted at it like, well, I guess the reason why you would do this is because you want the parking in the back. And it's like, well, yeah, that's actually what we want, is the parking in the back, right? So current existing uses, sure, don't fully comply with the ordinance, because the ordinance is also intended to be a stimulus for change, right? Literally, your client's property will be the first thing that somebody sees in the city of Portsmouth. If they're coming down Woodbury Avenue, it's the first thing that they're going to see. So yes, our gateway is designed to rethink how we go and do these types of applications. And so I'm curious from your team, my impression is you took what your cookie cutter, design is and put it onto the lot. And I'm curious, is there anything that you can demonstrate? I take just one thing you can demonstrate. I know you're not going to do the illuminated canopy anymore, so I suppose that's one. But one other thing that would say, hey, we looked at the zoning and we recognize that this is what the city of Portsmouth is trying to do. Here's how we've modified our standard model to go and better reflect what the city of Portsmouth is really trying to accomplish with this really important lot.
And we did, and we worked with the planning department and had multiple meetings and worked through the plan to be able to come up with something that fits on this lot. It's not perfect. It's a non-conforming lot. It is a gas station. If you were to put we looked at that. We looked at what we would call that village feel, where you move the property up to the front and put the pumps in the back. Pumps are louder. That would be against the residential zone. That moved the pumps back out front. There's more traffic when you deal with the pumps than with the single lane drive-throughs. So you'd want to move the pumps out to the front because that puts less traffic circulating the site. The site also has to circulate in a certain manner in order to get the delivery trucks in, the 18-wheel delivery trucks in for the gasoline. So there's constraints. There's constraints. And I know you might look at it and say, well, this is a cookie cutter of what you'd see in Nashua, at the Nashua store. It has a similar look. They're all very different because most of the sites that we do, we redevelop when we can existing gas stations. There's some environmental issues here that we're going to have to deal with. We're good at it. We clean them. We like the idea from a corporate standpoint, we're a family-owned business, that we do go in, upgrade the properties, clean the properties, put state-of-the-art equipment in. You know, there'll never be another leak on this property. Well, knock on wood. You know, I would get a notice to my phone if there's even a drop that gets between the double wall tank. So we do like to go in, we do like to pick properties that sometimes are challenging. And this is a challenge, and very often we have challenging properties. And a gas station itself offers a number of different challenges. But what we did here is unique. I wouldn't say we have any other properties that have this exact configuration. Every town we go into, we do try to modify to the lot that we're on, and we do try to be respectful. And I do think coming into the town, this will be a tremendous upgrade. Our sites are, I would say, best in industry. If you go look at any of our sites, any of our season sites, I would say they are best in industry. There's nothing close. But we do look at them, and we work very hard with the planning department to come up with something that would work here. Granted, it's a challenge, and we do need a number of variances to make it work. Otherwise, it stays, you know, in the configuration it is now, and I don't think that helps anybody.
Okay. And then lastly, very quickly, you know, in your arguments for the signage relief that you're looking for, the proposed sign is the applicant's standard sign is repeated over and over again. Again, what has been done, I believe the current mobile station has managed to, you know, be in service for many, many years with signage that is fundamentally in compliance with what we have. Why is it that you need the relief for the signage? And again, I appreciate that you got rid of the illumination that was a particularly significant concern.
Yep. So the signage package, and to say it's our standard signage package is, every one of our signage packages that we've had designed by architects that take the size of the building, the setback off of the street, whether it's a corner lot, and it's geared towards those particular components. Obviously, if this were a bigger store, bigger signage. This is a medium-sized store for us, and it's probably a middle-of-the-road signage package that we get from the architects in terms of not making the signage too small on the building. Obviously, you want large signage on the building because it drives business. But then we also don't want signage on the building that's too large that's going to take away from the aesthetic look of the building. These are the designs we get from the architect that say this, from an aesthetic standpoint, this is the signage you want on the building. We don't oversize, and we don't placard our building with signage. If you see in the pictures, the signage is actually, oddly, when you look at it, comes across as almost minimal. But nonetheless, for the aesthetic component of the signs, to be able to see the signs as you're coming down the street, approach the intersection, prepare to pull in, see the price, obviously, it drives a lot in the gasoline world, see that from a distance that people can prepare to stop and not jam on the brakes and pull into the site. It all goes into the signage package. So to say it's our standard signage package, it is.
I'm just reading what was put into.
But they all vary.
Your
But it is
application.
very similar to every signage package. If you've looked at the pictures we've given you, this signage package is going to be the same, but it's smaller than in Nashua. If you saw some other signage packages from some other, what we would call mid-size or boutique-size sites, it would be very similar.
Okay. Yeah, and I understand certainly your competitor across the street is in a different community and has different requirements that they have to meet. However, again, we're trying to establish something here in the city of Portsmouth.
Yep.
So, thank you, Madam Chair. I appreciate your indulgence.
Mr. Rossi?
Maybe one way to address some of the questions that my colleague, Mr. Rayum, just posed to you is to, with regard to the specific considerations that you've made in your design, looking at the objectives for the gateway neighborhoods and just reading through them. I'm not going to read the whole thing out loud because I'm sure that you studied this carefully. One of the objectives is to encourage walkable mixed-use development. So can you tell me what specific design feature here enhances the walkability of the area?
Sure, and I could have the engineer talk about this.
I mean, you should be, anybody point it out to me.
We've added a walkway that comes off of Woodbury, so in speaking
Can you
with-
use the pointer so I can see what you're pointing at?
Is this the pointer here? Not the pointer, I don't want to turn off anything.
Yeah.
This is not, that's, here, I'll just do it by hand.
But then-
Don't touch it. Don't
then
touch the screen.
Don't touch the screen.
Plus, we can't.
And you need to take
You need
the
to take the
mic
mic.
with you. We're also state of the art.
That works.
So when as the site's configured right now, I wouldn't, you're right, I wouldn't consider it very walkable, and there were no features that are built into that because the site's.
Okay, well, maybe we should move on to another aspect of the goals of the Gateway District then, and maybe you can point out a specific design feature that addresses the desire to create quality places by allowing for whole site development with meaningful public spaces and neighborhood centers. How is, was that incorporated into your design anywhere?
Yeah, and we actually discussed this. So in adding to this the fresh food service and the ability to gather, there'll be a small area. It's counter service, but there is a small area within the store that is accessible through the walkways. Again, it's not a park, it's a gas station, but that's probably about the best we can do. We don't always add those components, those walkability components to all of our sites, but again, in speaking with the
What's the
planning department-
walkability component again? Because I thought you said you didn't have anything.
No. So what we're doing off of Woodbury is tying into the side of Woodbury to have a sidewalk that comes down,
Okay.
and then you can cross over into the location.
I see, okay, thank you.
You're welcome.
Ms. Murchison.
Hi, so I think, I understand the argument that this is what is there now. It may not be a lot that actually furthers the objectives of the Gateway District zoning. However, I don't, this is not a one-for-one swap. This is a significant expansion of this lot. What currently is there with mobile is a little snack shack. This shop, this is, and I use that property all the time. This is a significant expansion of that market. And to me, the most problematic aspect of it, or the problematic aspect of it, is that drive-through. I realize there's drive-throughs at Aroma Joe's and Dunkin'. Those are not directly abutting the housing that's right in back of it. But there's just a lot going on this site. What I'm asking is, can you eliminate the drive-through? I mean, people are coming into this property to get gas, run into the snack shack. Do they really need to go through a drive-through too?
Well, I could let the client speak to that, but with respect to the comments about expanding, I will say that what I just was told by the engineers is that the building is 1,000 square foot less, smaller than any of their other stores, just because I was kind of getting to comments earlier about, the cookie cutter sort of place, and we are reducing those fueling stations. As to whether or not we can eliminate the drive-through, I mean, that would be, I'd have to let the client speak to that. But I will say again that there is buffering. There is a significant distance between the actual building that is on the other side of that fence and to what we are proposing to do here as well.
But I think that the issue is, and with all due respect, I don't find the analogy with pumping gas apt with going through the drive-through, because first of all, I think people use those bays less frequently than the other bays. And secondly, when you pump gas, you have to turn off your car. So there's no noises coming from your car, and people generally just get through very quickly. I mean, there's a significant residential neighborhood in back of there. I find that part of it very problematic, so perhaps they could address whether or not, I mean, it just seems like there's a lot. I mean, this is more a TAC planning board thing. There's a lot going on this site now.
Does anyone want to speak to drive-throughs?
Hi. And I do understand your concern. The drive-through use, and I understand cars will idle in the drive-through. They won't get out, they won't slam doors, the radios won't be, blaring, which sometimes you do see. The drive-through itself, the use of the drive-through itself, tends not to bring any additional traffic onto the site. What it does is if somebody's not looking for fuel, but they are looking for something from the convenience or the fresh food offering, they can get it through the drive-through and leave the site. They don't even go into the front court. So it's not as if there's going to be this doubling of the use, a doubling of traffic on the site. What we find is most of the people that use our drive-through are people that aren't getting gas. Once people stop, get out of their car to get gas, they go into the store. So it's not as if it's this sort of amplifying factor of traffic on the site. I'm not sure if that answers your question.
I don't understand why people just can't go into the store. I mean, this is you have an expanded menu. It might take people a long time to order through the drive-through. I think most people, well, I don't know. It just seems like in order to alleviate some of the pressure in the back, it might just make more sense to get rid of the drive-through. You'd have less variance relief, but anyway, thank you. I appreciate your response.
Other questions for the applicant, Mr. Neese?
Yeah, if you could, I'd like to go back to the sign issue again. I've got a couple questions on the signs. The first is on the aggregate sign area. And I think that you referred to it, and in the write-up you referred to the increase in the aggregate sign area as fairly minimal to allow for a slightly larger aggregate sign area. I just want to confirm that what you're looking for is a doubling in the aggregate sign area, correct? You're going from 223.5 to 453 square feet, according to your memo?
I think I might have been talking about the 100 to 135 square feet.
Nope, I'm looking at the part of your memo that refers to the aggregate sign area. And you specifically say that it's a minor increase in the aggregate sign. I just want to make sure that what we're really looking at here is a doubling. It's not a typo or a mistake here somehow.
I suppose it's close to a doubling, yeah, that would be fair to say.
Okay. The next question I have is I'm trying to understand the height of the signs a little bit, because it's hard for me to get in my head how big they are. You've got photos on, I forget what page it is, but your photo 5 and 6 show the existing mobile signs. Would you happen to know how high those are? Because I'm trying to get a sense of how much of an increase you're talking about here. And I can't really tell from your other picture because it's not the same view. It's from a longer distance away and it's a different perspective. So it's difficult for me to tell, what the difference in sign height is going to be here.
The engineer thinks maybe 20?
That's my best guess.
It's a guess.
Don't know the exact.
Yeah. But we're not sure.
You think the existing ones might be 20?
Yeah,
Okay, thank you.
give or take, so.
Yes, Mr. Mattson.
Yes, I heard a few comments about the small lot size, and I was wondering what led you to say that, because it's basically 4 times bigger than what the minimum lot size is, and pretty similar to the adjacent lot in Portsmouth on Woodbury.
I think, well, it's small in relation to the requirements of the ordinance. I mean, there's a lot of things that just to put this project on this lot, we're here asking for relief for at least a number of these things. Given the setback constraints for some of these things, you just can't do it. I mean, and what's on there now is glaringly violating all of these things as well. In fact, you want to talk about the neighbors on the other side, these pumps go right up against that lot, the way it's configured now. But yeah, I mean, it's a normal sized lot, yes, but for this kind of use, you're gonna bump into setbacks and constraints, and given that it's pre-existing and non-conforming. And again, it's best I can tell, it's been this size since at least the 50s, and so it certainly doesn't conform. With what's on there now, and I think anybody who's going to try to put anything on there now has got to come to you one way or another. Well, thank you very much for the Honorable Board for the time. I tried to get through as fast as I could. Thank you.
Okay, is there anyone in the public who would like to speak in favor of this petition? Is there anyone who would like to speak in opposition? Anyone who would like to speak to, for, or against? Okay. The public hearing is closed.
I would like to start by making a motion to approve the special exception as presented and advertised.
Okay, is there a second to that?
I'll second the special exception, yeah.
Yes, okay, thank you.
So the special exception pertains to the use of the building for convenience store C2. And, excuse me, I'm evaluating that without regard to the specifics of the drive-through, which really requires a variance in addition to the special exception. So this does not, my comments here do not contemplate the presence or absence of the drive-through component. But this is a use that's permitted by special exception. There's no hazard to the public or adjacent property on account of potential fire, explosion, release of toxic materials. I agree with that. You know, it's a convenience store, and the risk of such things, even with a kitchen, which sounds like it's not going to be preparing a lot of hot food anyway, is de minimis. No detriment to the property values. The applicant has made the point several times that this is a commercial use in a heavily commercialized area. There's nothing about this building and its use as a convenience store that in any way will affect in a negative way, the surrounding properties. Traffic or safety hazards, the ingress and egress to the facility, to the lot is very good. It comes from two major roadways, and I do not anticipate that the volume of traffic will be significantly different from what's currently being experienced on the site. No excessive demand on municipal services, et cetera. There's nothing about running a convenience store that would place any such demands upon our municipal services. And no increase in stormwater runoff onto adjacent properties. The whole thing is a impermeable surface at this time, so there's really no difference in how that will be affecting stormwater runoff. And that is my motion.
Does the second have anything to add?
Nothing to add.
Okay. Any discussion?
Thank you, Madam Chair. Yeah, I'm mostly on board with the special exception. I think they're pretty much there. I still do have some of a concern. I know that you talked about the drive-through being tied to a variance. Currently, the way that the applicant has presented this, it's tied to a variance. I still think the use overall with a drive-through and the nature of it, I would still like to see the special exception have some type of stipulation associated with it regarding certainly very late night hours, not being a 24-hour-a-day function. Don't know exactly what those hours should be. I guess my thought would have been to have given the applicant an opportunity to provide that info to us, perhaps either through a delay in making a decision on the special exception, or if they could give us something. I just still think it would be an important aspect to it. Agreed, there is currently a need for a variance, which kind of ties the applicant's hands, but that could be potentially separated either with this application or a future application from someone else. So I'm not sure I'm 100% on board with the motion.
Can you propose a stipulation?
I guess my concern is I really would like to have that come from the applicant and tell us what their hours of, proposed hours of operation would be. I just think this is so close to this residential neighborhood. It's my hugest sensitivity about what's being proposed here, that I just think it's something I would like to see incorporated into it. Again, as you pointed out, may or may not be a truly detrimental omission if we don't include stipulation. I just don't. I could propose something, but I would not want to tie the applicant's hands necessarily. I'd like to hear from them what they would propose in deference to the neighboring residential area.
I heard 5 a.m. to 10 p.m. from them.
But my problem with a stipulation like that is that it has embedded in it a tacit assumption that the drive-in will be part of the operations, and without a variance, there's no reason to make that assumption. In fact, I will not be supporting that variance. So I do think those are separate issues. And conceivably, if the building were to be relocated and provide sufficient lot line clearance, we might be willing to consider something like that. So I think I'm satisfied with, well, obviously I made the motion, but I'm satisfied that it doesn't get us committed to allowing the drive-through operation.
I would just say that I agree with that basically this allows them to have cooking on the premises. The building itself, should this not be approved, would still be there and would still leave open the question of the drive-through and all of those other things. So I see this as quite specific. Anybody over here? Comments? Be ready to vote? The vote is just for the special exception to allow, what is it called, the store two?
Convenience goods too.
Okay, it sounds like double, doesn't it? Okay. Mr. Neese?
Yes.
Mr. Mantle?
Yes.
Ms. Marchison?
Yes.
Mr. Rayam?
No.
Okay. Okay, Mr.
Don't make me
Rossi?
laugh before I have to vote. Yes.
And Mr. Mattson?
Yes.
And the chair votes yes. Okay. So our special exception is taken care of.
Okay. Would you like me to go again?
Sure.
I'm just, just to start a discussion. First, I'd like to just make a comment on sort of the general gestalt of the sheer volume of variance requests. I think that I have a newfound respect for my colleague David's ability to phrase things in a very positive and non-confrontational way. To me, who does not possess such a skill, it does seem to me like this was a design that was made in flagrant disregard of the Portsmouth zoning objective and just shoehorned into a spot where it's an overly intense use of the land that doesn't comport with what we're trying to accomplish. So I don't have any problem with a gas station. I have no problem with a convenience store. Aesthetically, it looks pretty nice, but there's several aspects here going down to more specifics that I do object to. I am particularly concerned about variances as they're labeled here, number 4 and 5, which pertain to the drive-through operations. It is absolutely not a good assumption that signboard and its use and the traffic and the volume of communications in the signboard and all of those things, that we have any way of judging that would not be creating a disturbance to the residents in the adjacent property. There isn't a lot of residential property in the area, but unfortunately, this design proposes putting in the one thing that is the most egregious to residents right next to the residential use. So the orientation of this makes it impossible for me to support variances that are labeled on the handout, thank you, as number 4 and 5. I'm also concerned about the sign. Just looking at the photographs that were provided here, the signs are big, they're tall, and it is the first thing that people will see entering into Portsmouth. I don't think that is the image that we want to project for our town. It's not consistent with what we're trying to achieve in the signage aspects of our ordinance. So I will not be supporting the variances labeled 7, 8, and 9 in the handout. The lot line variances, it's not clear to me how much of that is driven by the desire to have the traffic wrapping around the back of the building, but I would probably go along with the lot line variances because it does have 2 frontages, and it is a logical way to configure a gas station, a convenience store, and we have made similar variances in the past on Lafayette Road fairly recently. So those are my thoughts.
I guess I have a question about how we want to take this on. Shall we consider the drive-through as a separate variance? And the 4 and 5 that go with it, and then the signs separately? Because I don't know that everybody's thoughts will be aligned on those. So I guess I'm looking for some guidance here.
Yeah, I don't know.
Yeah, Madam Chair, I mean, towards that end, I guess here's where I'm coming from. I think that the applicant's proposal has lots of interlocking parts to it. As Mr. Rossi pointed out, they're asking for a lot of relief here. I think it could be potentially cut down substantially. I'm willing to give some level of relief. My fundamental concern is to have some kind of demonstration that, no kidding, recognizing that we went through a lot of effort to create this gateway district. We put a lot of these requirements into place. They weren't just there for certain things. The intent was, no kidding, this is what we want this to look like in the future. Now, the gas station application may need some level of relief. It may not be truly practical for all the things that you need for a gas station. And I think the applicants, ultimately when questioned, came back with some decent answers. I'd like to see that more flushed out. I guess my instinct is, while this is all interconnected, my instinct would be for the variances to not take an action tonight, but to do a postponement. I know we're not the HDC, we're not the TAC, we don't like people coming before us multiple times. That said, with the complexity of this and with the pushback that we had, I would have appreciated maybe more work up front by the applicant, but at the same point in time, I think in fairness to what the applicant is trying to do here, because I just think there's some opportunity for them to make a more persuasive case as to how they're trying to incorporate what we're looking for, and maybe do something with their signage, that they could come back to us and give us another proposal. And I know in general we don't like to do that, but that's my instinct here is let's give them the chance to rework their proposal.
Any thoughts down this way on a postponement?
Well, thanks, Madam Chair. I mean, my concerns are identical to Mr. Rossi's. And I would, if we're going to vote on the variances, I would suggest splitting out those groups that he talked about. I could support a postponement. I guess I'm confused whether, with a postponement, whether inviting better rationale for what they've got here, or are we looking for a new proposal? Because I think we should be clear which it is. I think I defer to staff, but I don't know that we want to get into the position of soliciting a new proposal.
I'm going to tell you what I think I'm hearing that Mr. Ames is largely looking for. How to make this work with the gateway community, I think, is one of the most difficult things we could ask, because, I mean, it's gateway, but they're allowing gas stations. And I don't know if having a playground here is going to make it friendlier. And I know that's in jest, but I also am not really sure what we would be looking for to make that connection. Yes.
Thank you. If I could elaborate a little bit, I mean, I think I've expressed it. My concerns really center around the drive-through and its impact on the very close neighborhood with a large apartment building like right there. The Dunkin' already is like right next to there. How people put up with that, I have no idea. But I don't think we need to duplicate that further up and put yet another imposition on that neighborhood. The signage, I have a lot of concerns about that in terms of, why do you really need this relief? What is really being accomplished other than it gives you the sign that you want to have? So I would love to see something that comes back that would ideally eliminate a lot of that variance requirements. And then just in terms of some of those other gateway, like the build out on the street side, again, may not be practical, but what we were trying to do with the ordinance and through, being there for a lot of the public work sessions and charrettes that we had that developed a lot of the concepts, the demand from the people who were there and coming out of it was, let's put our thinking caps on. Let's look at a different way of building out these neighborhoods rather than just the same old thing that we've done back to the 1950s when this is what it would look like. Let's rethink that. And maybe it's not possible. And I think the applicant did start to give us some good reasons why, the configuration that they have maybe makes the most sense, and wouldn't be fully compliant with what we're trying to accomplish. But I think we need to understand that, and then as a board, be able to balance that against here's what the ordinance is trying to accomplish. Here's the constraints that the applicant has. Right now, I don't have a very good sense of that balance. I have a sense of balance that the applicant is asking for exactly what they want, and that the ordinance and our goals for the Gateway District are getting very little.
Well, sorry.
Ms. Marchison.
So I think, somewhat surprisingly for me, I probably would be in favor of a continuance. I would like a little more information on the relation of this to the Gateway, because as I started to analyze this, the reality is that when you get to 9 variance requests, it's almost like this project is illegal. And also trying to look at what the Gateway District is trying to accomplish. I wonder, given that this does abut a residential neighborhood, maybe this was intentionally put there this property was intentionally zoned so that maybe there could be some transition to the very residential corridor down Gosling. And, if that's the intent of the policymakers, I think that's something we really seriously need to consider. So the spirit and intent, I think it's missing, frankly. Maybe it makes sense to make this still a gas station. I don't know. But to me, the fundamentally most problematic aspect of this is the drive-through. And if it were, and perhaps if they didn't have the drive-through, maybe some of these build-outs, these lot lines would shift. I don't know. Maybe there could be other opportunity. I mean, does it make sense to do like a playground or something here? But, I as a parent, I would not want my kids anywhere near that.
This is part of the conflict.
But
As we learn, there's legal restrictions on reuse of former gas.
because there's underground storage tanks here. So, it's possible that was the issue with the Getty Station in downtown Portsmouth. But I think just also in terms of digesting the amount of material that we have had to digest tonight, I would appreciate the opportunity to make a more considered decision on this application.
Well, let me just ask, I'm sorry, yes, Mr. Mann.
Couple of things. I think the design overall is an improvement what's already there. I don't think it's possible to build a profitable gas station in the Gateway District, because the Gateway has nothing to do and is very anti-car traffic. It's meant for walkability. And not too long ago, we had an application to redo Burger King that had 13 variances. Unanimous, all 13.
No, you and I voted against it
Because
of the Gateway District.
because of the Gateway District. If we're going to go through all the work of the zoning to just grant 13 variances, what was the point of the zoning in the first place? I don't think it's possible you can build a gas station in the Gateway District without variances. So
I don't know if
I mean, you could probably put an electric car charging station right there with a convenience store, but you're not going to be able to do it for a gas station, especially a gas station that cuts down from, 12 to 8. So you're already getting a 1/3 cutoff on the amount that's going to be there. In one respect, I do like the proposal, because I think it does a good job in improving the property that's currently there now. In another respect, there's too many variances because of the Gateway District on top of it.
Go ahead, Mr. Chairman.
please go.
I was just going to discuss if, it seems to me I'm hearing that the drive-through is a big obstacle for most of us. And if that's so, and we even do want to do a postponement, maybe this is information that should travel with that postponement, that is not acceptable in the next plan. And we could look at that one particular variance before we send it.
Before we, oh, I'm sorry, David, do you want to say
No,
something?
no.
Go ahead.
Before we sort of grasp onto the idea of a postponement, I think we should consider how our actual process would play out here, okay? So, my understanding of our process, and I would like to consider it in the sense of where our jurisdiction is and isn't, and also giving the applicant a fair chance to come up with something that can be approved. Okay, so the way I understand our process is we would go through these 9 variances individually and say yay or nay. And the applicant would then be able to take that information and come up with a design that did not need those variances without any further guidance from us as to whether or not, for example, a gas station is possible. They may have some ideas we haven't thought of as to whether or not they could make a reasonable accommodation for pedestrians in transition. I don't know. I'm not an engineer. I'm not an architect. I'm not a landscape artist. I can't figure that stuff out, and I would feel reluctant to wander out of our jurisdiction and say this is or this is not possible. I think if we stick to our process and simply give the emperor's thumb on each of these variances, the applicant has a fair chance to come back with something that does not get tripped up with Fisher v. Dover and try again. And I think that's a fair process. I don't think there's anything flawed in that. So I personally would not be in favor of a postponement. I mean, it gets messy because we don't know what we're asking for. We don't know how to
Oh,
guide
I
them.
do think we need more definition, yeah. Mr. Ram.
I guess, and my one concern with the yea or nay voting on everything is that exactly that, Fisher v. Dover. It can get very tricky, it can get very legalistic, it can get to the point where now it could potentially be more of a issue that would have to go before the courts. Is the drive-through, well, first of all, the drive-through variances are all tied to distance. So if the applicant's able to solve that, perhaps they can have their drive-through, again, without any type of variance relief from us whatsoever. There is a distance that is established through the ordinance. But, and again, I'm potentially willing to accept some level of variances. I just think that what is being asked for is too much. I think that we've had lots of discussion here. We've been going on now for well over an hour. I do think that we've expressed what our concerns are. I think there's an opportunity here for the applicant to give a second chance if we postponed. I don't like doing that overall. I'm with Ms. Margerson. It's kind of rare, but at the same point in time, with the complexity here and in fairness to the overall process, I just think it's the right thing to do for the moment and could potentially keep us out of a conundrum where we denied something and the way that they come back with it, we feel Fisher v. Dover applies, and then they really are now potentially having to seek refuge with the courts to get something done.
Can I just
Yes,
add
please.
something? I would hope that you would consider, if you're asking for a postponement, to provide what information you're asking the applicant to provide with that, or is the postponement for them to redesign what they've asked for? Because that's two totally different things.
Yeah, I guess I would just, to add on to that, if they change the design, is that a new application, or is it still, this application postponed?
If there are substantial changes, then it would be a new application.
Substantial, okay.
But I fear that if we do all the variances and invite them back again, then we're going to be in Fisher v. Dover, because how different can a gas station be from a gas station? you know? And that's something I would put on the board for everybody also.
What if we didn't do the variances individually? What if we just said the whole package is approved or not approved? Then could they,
Wouldn't, I don't know if
would that
would
fall too
change
far
it.
outside of our process?
You could do that, or you could do just the drive-through lane variances as a package, just the sign
If we
variances.
gave the whole thing an up or down,
That's
and
an
if they
option as
came
well.
back and changed some, you know, portions of it, the other portions would still be approvable. I mean, we suppose we said, no, the whole thing is a no. And they came back and they said, okay, we're gonna move the building over 8 feet or whatever it takes, and you know, we've got this clearance, and it's a substantially different
It's up to us to
proposal.
decide what's substantial.
The board would make a determination if it was a substantial enough change to not. be-
Meaning it would not require all the same variances that it
Right.
requires now, so. There's some risk for Fisher v. Dover, but we're all, you know, we're all grown ups and we know what we're trying to accomplish here, so.
Yes,
Madam Chair, just to move this along,
yes, please.
I will make a motion to postpone consideration of the application until our first meeting in May, with the expectation that the applicant address significant concerns that this board has related to the variances associated with the drive-through and its impact on the adjacent residential property, with the signage variances and what can be done to potentially mitigate those, or reasons why the signage variances need to be in place, what specific reasons there are. And then lastly, the remaining variances, simply either a redesign or an explanation as to why, better explanation as to why the objectives of the Gateway District and how it could relate to a future planning for that are really not properly applicable to what the applicant is attempting to do with the gas station use and convenience good use.
That was your motion?
That is my motion.
Did not get a second. Is there a second?
Second?
Okay, all right. Does the second have anything to add?
No.
Is there any discussion?
Please God, no.
Is that all right? Okay,
Can
so, yes,
I
please.
hate to do this, but could you reread the motion?
It's a complicated one.
At least just detail the information that you're asking the applicant to provide next month.
Oh, okay, you want me to do it?
Yeah.
So again, variances associated with the drive-through, we want those addressed in terms of either eliminating them or providing substantial justification as to why they will not be impactful upon the neighboring residential location. The signage variances, either eliminate them or again, describe why they are critical to the proper operation of this, this as a gas station use. And then lastly, the other remaining variances, some type of either, again, elimination of them or an alternative, or an explanation as to why the objectives of the gateway zone cannot be fully met with this gas station, if this remains as a gas station convenience goods to use. If that makes sense.
Okay. So a vote for this does ask for a very directed postponement till the first meeting in May. Okay. Ms. Janice,
Yes.
Mr. Mannell,
Yes.
Ms. Margison,
Yes.
Mr. Rayam.
Yes.
Mr. Rossi,
No.
Mr. Mattson.
Yes.
The chair's going to vote yes. Thank you.
We're not busy in May.
I guess in 2 weeks.
So you have to go at the- Oh, okay. All right, so the next item of business for tonight is, excuse me, let me just find my things.
Number 3? Jesus.
Item D, The request of Lonza Biologics, owner for property located at 101 International Drive, whereas relief is needed to construct a canopy with supporting structure, which requires relief from the following. 1, a variance from Section 304.04C of the Pease Development Ordinance to allow a canopy and supporting structures for an outdoor patio to be located within 70 feet of the property line. Said property is located on Assessor Map 305, Lot 6, and lies within the Airport Business Commercial District. I'm going to ask you to hold 1 second. We need to vote if we want to keep this meeting going. I think we've reached that time, yes?
I wouldn't put that to a vote right now.
Yeah, exactly. That
We'll
was
just
my.
go over that later. We wouldn't close you
No,
down.
Technically, it's after 10
It's
o'clock.
technical, but it's not, we
You wanna do
hardly ever have we just shut out these very patient people.
Well, we only have 2 more to go, right?
Yeah, yes, yes. It's just what one does, but, okay, we can do it after you.
We
Go
got
ahead.
0 to go.
You're on.
Good evening, everybody. Madam Chair, and consonant with that comment, I'm hoping that this application is far simpler than the ones, or certainly the last one, and will go much,
Otherwise,
much
we
faster.
will end this meeting.
Right. My name is Chris Hilson. I'm an attorney at Donahue, Tucker, and Schindel. I represent Lonza Biologics, Inc. With me today is Christopher Tiernan, who's an architect with Lonza in their CapEx and planning division. As the colloquy that you read, Madam Chair, would suggest, maybe this is a little bit off the menu. Mr. Tiernan and I were trying to figure out how often this happens. This is a referral from the PDA associated with the variance.
Yes.
No, we have this.
We've
We
had this, yes.
So
Yes.
you're very well aware of this,
Yes.
that we are seeking a recommendation from this board relative to this variance. And I'd like to talk about what exactly we are talking about. If the powers that could be actually could move to Exhibit 4 of our application. I think that's the technical specs. There you go, that one right there. So, understanding that you need me on the record, the PDA has already approved much of what Lonza wants to do. And so what we're here about tonight, I won't touch the screen, are these 3 poles. That's it. That's the only thing that we're here on tonight. That's what has been referred to this board for consideration. They are within the 70-foot setback within this property. And so that's what we're here to ask for a recommendation of. I think this property is relatively well known, probably to everybody in Portsmouth. It's a large lot. It's 46 acres off of International Drive at 101 International Drive. It's dominated by Lonza's industrial facility there. They make, as you all know, they make medicines there. And as something of a hopefully not a frolic or a departure, I've been in that facility before as part of my representation of Lonza and other things. It's very impressive on the inside. They make medicines, obviously. They have clean rooms and suites. In order to go in them, you need to gown up. You need to get into that facility. It takes a significant amount of time to do. And while you're in there, you are breathing purified air. There can be no windows in there. And so what they're trying to do is they're trying to put a patio on the outside for their employees. They employ 1,500 individuals. Those are good jobs. And having been in that facility, I can understand why you would want to go outside for your breaks and your lunch. Actually, the facility is pressurized with purified air. The pressure is different on the inside because you got to make sure everything comes out of the facility and not into the facility. So against that backdrop, what Lonza wants to do is create this patio area on the westerly side of its structure. And as you can see, the poles will be within the 70-foot setback, front setback of the airport business and commercial zoning district there. And so this was referred to you because in my somewhat outside view, there's no definition of structure in PDA's land development ordinance. which is in sharp contrast to some other towns I represent where we fight over what is a structure and what's not a structure. They've deemed those 3 poles to be a structure, and we're asking for a dispensation to put them in the 70-foot setback here. Again, the Pease Development Authority, I believe it's at Exhibit 7 in your packet. They've already looked at this use. They've already supported this use, and they just want to refer this to this tribunal for those 3 poles. So, the standards for zoning, the standards for a variance within the Pease Development Authority's land use regulations, they're well known. As far as I can see, they're functionally the equivalent of 633, or the ones that you typically deal with. Attorney Mulligan and Attorney Drescher well articulated those, and I'm sure you're very well aware of them. But I think this falls well within an acceptable variance. Incidentally, I'm just reminded by the blue, this same type of setup is allowed down the road at the Red Hook Brewery. I was looking at a satellite map while we're listening to the other presentations. This same type of use is right down the street. The variance criteria, as you know, there's no adverse effect for the diminution of value. We're talking about 3 poles. It's going to be approximately 8-inch diameter poles. There can be no diminution of value in the property values, especially when they're set back as far as they are. The closest one's going to be 45 feet from International Drive. The variance is going to be in the public interest, and as you know, that element's closely related to the spirit of the ordinance. The PDA has also already found that this is not going to alter the essential characteristics of this neighborhood. You're talking about 3 poles within a 70-foot setback. Frankly, I think the screening, if you look at the landscaping here, I think that would probably break up to a certain extent the industrial nature of that facility out there. So this use, I think, actually will add to the facade, and certainly will not impede or pose a threat to the public interest. Incidentally, the road, which is to the west of the picture that we have on Exhibit 5, so at the bottom, there's an incline there. So to the extent anybody's concerned about traffic coming off of International Drive and driving up into this, there's a fairly sharp incline there that's going to block any errant traffic. Beyond that, I submit that this would also be an unnecessary hardship. As you know, there has to be a no fair and substantial relationship to the general public purpose. The public purpose of the setback is you want a viewscape here onto the use of these particular lands and to provide the necessary space for traffic and other users when they look up at the users of this property. A few poles intruding on that 70-foot setback, that has no substantial relationship if you were to impose that particular dynamic or that prohibition on this thing. And the use is eminently a reasonable one. As I told you before, this is to give their employees a space to degown, breathe natural air, sunlight as well, because there's no windows there. It's not like you can open a window or even look out a window when you're in that facility. So the unnecessary hardship, to my mind, is met because there's no substantial relationship to enforcing this particular setback prohibition against the proposed use. Granting the variance will provide for substantial justice. As I said, down the street at Red Hook, they have the same type of setup. It's not within the front setback, in fairness, but it is consistent with that neighborhood and consistent with other uses in that PDA, and certainly is not going to change the facade for that. And so, finally, I would submit to you, and the reason I'm going kind of out of order, the PDA's variance criteria are out of order, at least in comparison to the statute, but the spirit of the ordinance is not contravened by this. We're talking about 3 8-inch diameter poles within a 70-foot setback in connection with what I would submit as a rather attractive feature that Lonza would like to build there. So I'm happy to answer any questions they have. I've tried to go rather quickly because you've been through a night already, and I in my heart of hearts, I don't feel that this is a big ask, and so I'm happy to answer any questions the board may have.
Ms. Marchison?
Just a quick question. This area will only be available to Lonza employees?
No, that's my understanding. Last time I was there, I had to go through 3 different checkpoints, given the nature of the use of that property. So to answer your question, yes, it's going to be confined to Lonza
Thank you.
employees.
Any other questions? Mr. Ram?
Thank you. So I am trying to understand, I know you're talking about these polls, but, and unfortunately, our iPads are so slow and Mr. Tiernan's drawings are so detailed that mine's still loading. It's been loading for like 5 minutes now, trying to bring this image up. But, so the blue banners we see there, those are stretched between the poles to provide coverage? What exactly are they?
Yeah, so, and again, Exhibit 4 may demonstrate this a little bit better. You're not going to be able to see the triangular sail canopies or whatever they call it, but the poles, 1, 2, 3, 4, 5, 6, and there's triangles between those poles. So I'm not sure if that answers your question or not.
So the triangles are what, like a canvas?
Yes, they're a semi-permeable canvas. They're a sunshade so people don't get sunburned.
Yeah, and the Pease Development Authority did not consider those part of the structure? They only considered the poles themselves the structure?
The referral in your packet at Exhibit number 7 simply refers the poles themselves to the consideration by this tribunal.
Okay, and you said there's 3 of the poles that are within
Yes,
the setback?
the closest
Not all
one.
of them, correct?
Yep, the closest one at Exhibit 4. They've drawn in. This is your 70-foot setback here. The closest one is 45 feet 4 inches from that setback. Still a very substantial setback away from International Drive, and because it's on the diagonal, you're at almost 60 feet for the furthest one away on that westerly side of the building.
Okay.
The easterly side of International.
And how many total poles then are part of the structure?
There's 6 total. I'm right about this, Chris, right? 6 total poles. Obviously, these are far. The back 3 are outside the setback. They're
Yep. So
not.
there's only half of them, 3 that are of concern to us.
Exactly right.
Okay, thank you.
Any other questions? Yes, Mr. Rossi?
Sorry. What consideration, if any, was given to emergency vehicle access or emergency, sort of ingress and egress from the area, things of that nature?
So I'm not sure, there might be a plan within your packet, if you stand by it, showing the overall facility. It's not complete. At Exhibit 1, you're not going to see the full spectrum of what I'd like to tell you right now. But number 1, what you're going to see is you have 2 points of ingress for emergency service vehicles on that westerly facade or westerly side of that building, and that wraps around, as you can see, to the north and to the south. What Exhibit 1 does not depict is you have Goose Bay Road that comes along the backside of that structure. So you basically have the structure ringed by access way for emergency service personnel. So if I may, and again, Exhibit 1's on for the record, Exhibit 1's on the display right now, but unfortunately it cuts off. You have Goose Bay, it's Goose Bay Road, right? Yeah. Yeah, Goose Bay Road runs along here. So you have this whole structure almost ringed by access ways for emergency, and this is a parking garage here, and there's an entrance to the east on that, off of Goose Bay as well. Please.
If you come to.
Yep, come to the.
Mike.
Thank you, Christopher Tiernan with Lonza. Regarding the access, the access is maintained, so the patio is designed for emergency vehicles to go over it, and the furniture is movable. We've coordinated this with the fire department. We have their approval. So if we did not do the sunshade structure, all of the other scope of the project is approved, including maintaining access all the way around.
Thank you.
So in other words, the sunshade poles, the fire department looked at that and said, yeah, no problem, we can get through that.
Correct, no problem. They sit outside of, they wanted to maintain a 20-foot road width. So if you were to look at the details, those poles maintain that road. The pavers do change, sort of the texture of it, but they're all, they're designed for vehicle loading, so you could, in an emergency, still get that 360 access that we have.
Thank you.
Anybody else? Thank you.
Thank you
I
very
will
much.
open it to the public. Is there anyone who would like to speak in favor of this petition? Anyone to speak in opposition? Anyone to speak to, for, or against? The public hearing is closed. Yes. Mr.
Madam
Rees.
Chair, I'd like to make a motion to recommend approval of the variance as advertised and presented.
Is there a second? Thank you, Mr. Mail.
I'm going to, with your permission, I'll go through the criteria. I'm going to go through the order that they are in the Ps things, so that,
Sure.
otherwise I'll get lost. Number one, there will be no adverse effect or diminution of values of surrounding properties would be suffered. It's difficult to see how 3 poles would have any impact on the value of any of the properties, either of Lonza Biologic, they wouldn't put them there if it did, I suppose, or anybody else in the vicinity. This is a very minor variance request. Granting the variance would be a benefit to the public interest. Arguably, allowing these sunshades creates a more attractive view for the public of Lonza Biologic to some extent. In addition, I think it makes use of the patio better for the people who are working at Lonza, who are members of the public after all. Denial of the variance would result in an unnecessary hardship to the person seeking it. I'm not sure I see the point of having people sitting at tables getting baked in the sunshine. This is basically creating shadow for them, and that is definitely a benefit, and it would be a hardship to be using it without that. Granting the variance would do substantial justice. It's difficult for me to understand that there would be any benefit to the public by disapproving this. There would be a loss to the applicant by doing so. The proposed use would not be contrary to the spirit of this zoning rule. I assume the setbacks on Ps are for the same reason they are in other places, to promote light and air, to prevent density and over-density. These are 3 poles. They're not going to have any impact on light and air. They're not going to really affect the density in any significant way. Because of that, I think that we should recommend it. I think that's the right language, right?
Yeah,
Mr. Mantle, do you have anything to add?
nothing to add.
Okay. Then we will take a vote. Mr. Neese?
Yes.
Mr. Mantle?
Yes.
Ms. Margison?
Yes.
Mr. Boehm?
Yes.
Mr. Rossi?
Yes.
Mr. Mattson?
Yes.
And the chair votes yes. You are approved. Thank you for your patience.
Now we have to do this and go after 10 o'clock. Now we have to decide.
Now we
Okay.
have to decide if we're going to, I guess.
Let's
like to
see, what do we want to do to these people?
Chair,
You've been waiting all night, huh?
I'd like to make a motion that we extend the meeting past 10 o'clock to finish the last one.
Is there a second?
Second.
All in favor?
Aye.
Opposed? No. Oh, you're in luck. You can keep going.
Thank you, Madam Chair.
You're going to vote no?
I didn't read this yet. Okay, the request of Adam and Reagan Rudick, owners for property located at 70 Highland Street. Whereas relief is needed to demolish the existing garage and bulkhead and to construct a new detached garage and bulkhead, which requires the following. 1. A variance from section 10.4521 to allow A, building coverage at 26% where a maximum of 25% is allowed. B, a 2-foot rear yard where 18 is required. C, a 2-foot right yard setback where 10 feet is required. And 2, variance from section 10.321 to allow a nonconforming building or structure to be extended, reconstructed, or enlarged without conforming to the requirements of the ordinance. Said property is located on Assessor Map 134, Lot 27, and lies within the General Residence A District. Hi, welcome.
Well, thank you. Thank you, Madam Chair, members of the board. For the record, Derek Durbin. I'm here on behalf of the Rudicks, the owners and the applicants that are before you this evening. They're both here in attendance as well. I think it was, I don't remember if it was David Witham that used to always say, on to the our favorite application of the evening. For me, it's my favorite application because it's the only one I have, but for you, it's the final one. So I will try to be as brief as I can here while addressing each of the criteria. So there is an existing two-car garage, as you'll see on the site plan that's up before you right now. On the property, the Rutigs are looking to demolish that existing building and construct a new garage in its place in a slightly larger footprint than what exists. The existing garage was originally constructed sometime in the 1930s and really isn't adequately dimensioned for two vehicles, two modern vehicles, I should say. Doesn't really have enough room, either length or width, to fit two reasonably sized vehicles and leave any room for anything else. In addition, the structure is compromised. It's rotted, as I pointed out in my written narrative, in several substantial areas of the building. The roof is also in need of replacement. A lot of that, is old age, but also stems from a tree having grown into the southerly elevation of that building. That tree has since been removed, but the damage exists. As I stated, the Rutigs would like to construct a new garage in that particular location, same as it exists now, of a slightly larger dimension. The expansion would not expand any further into the setbacks the existing garage encroaches into. As you can see on the plans, it's basically coming in towards their property instead of back or to the right side. In conjunction with this proposal, they are also seeking to reconstruct a bulkhead to the rear of their house. It's a very small bulkhead, again, not really adequately dimensioned to get in and out comfortably. It also, like the garage, has suffered from years of water damage, is in pretty poor shape. So they'd like to construct a bulkhead of slightly larger dimension to provide for better access in and out. Before I address each of the individual criteria, I would just point out that you should have received communications from two of the immediate abutters. One to the right, I believe that's the Conrads, right? The Conrads. And then one immediately to the rear right is what I would say. There's two abutters back there, but the ones right behind the garage structure have written letters of support for the application before you. The only other thing I would point out, just for background purposes, is that the Rutigs also intend to replace the asphalt driveway on the property that accesses the garage with a pervious driveway, which will constitute an overall reduction in impervious surface. I know that's not an issue for consideration for the board tonight. I would just point it out, though, because it is one of the sort of benefits, aesthetic, environmentally, associated with what's proposed this evening. So with that, I'll turn to the variance criteria, unless anybody has a question for me right now. Okay. Granting the variances will not be contrary to the spirit and intent of the ordinance or the public interest. The sections of the expanded garage will not comply with the building setbacks. However, they are adjacent to, or at least where the garage will be expanded is adjacent to open space on abutting properties. Will have little impact upon the light, air, and space of abutting properties. There will be no windows along the non-conforming aspects of the proposed garage. The existing garage does have windows, so in that sense, the neighbor's privacy will be better respected and protected with the garage that's proposed. Location of the proposed garage is the most logical area of the property constructed. It would be at the end of an existing driveway curb cut, so it makes most sense to put it back in that particular location. I did, in the written narrative, as an exhibit, attach a number of photographs of similarly situated structures throughout the neighborhood. I also put the snapshots of the tax map on there as well, so you could identify where those are. I would submit to the board the proposed garage and bulkhead expansions are reasonable, constitute a relatively minor increase in nonconformity that wouldn't be realized by abutters of the general public passing by the property. For the foregoing reasons, granting the variance will not alter the essential character of the neighborhood, will observe the public interest. Substantial justice will be done in granting the variances. I can't really see that there would be any benefit to denying them achieved by the public. It would obviously constitute a loss to the applicants to be able to reconstruct a garage on the property of really adequate dimension and minimal dimension to fit two modern vehicles side by side and have a little bit of room also so that they're not squeezed right up against the back wall of the garage. In addition, the bulkhead is really not, if you want to break your back and your head, is not really adequately dimensioned for access into the basement and is also in very poor condition. Those two things combined, unfortunately, do, even at relatively minimal dimensions, result in about a 19 square foot overall increase in coverage, which is a new nonconformity. But I believe that's a relatively reasonable request and have looked at ideas of how to reduce that. I guess it would be that you reduce the bulkhead to its existing dimension, and you can probably get there, but it makes very little sense to try to do that and reasonably improve the property. Surrounding property values will not be diminished by granting the requested variances. The improvements are consistent with structures in the surrounding neighborhood. What's proposed is tasteful. It'll aesthetically, environmentally improve the property. Submit that if anything, surrounding property values will be benefited. Federal enforcement of the provisions of the ordinance would result in an unnecessary hardship. The property does have special conditions that distinguish it from surrounding properties, such that there is no fair and substantial relationship between the general purpose of the ordinance provisions here, setbacks, building coverage, and their application of the property. As obvious, the property contains a non-conforming detached garage that already encroaches into the two applicable setbacks. It really can't be reasonably reconstructed or expanded without variance relief. The bulkhead and the garage were both constructed long before modern zoning standards were put in place without any thought to their placement at that particular time, or that vehicles would get quite a bit larger than they are today. So for these reasons, there are special conditions that make it distinguishable. And finally, the use is reasonable for all the reasons I've already pointed out. So with that, I'm hopeful that you will grant the variances that are requested, and happy to answer any questions you have.
Mr. Russell.
Yeah.
Mr. Matza, I thought someone's hand
okay.
went up there. Go ahead.
Yeah, I was just wondering, so does the request for the bulkhead contribute at all to the variances? Is that just the building coverage, or?
That's correct, yes. It does contribute to that 0.7% increase. So I think, again, this is a back of the napkin calculations, and believe it's 19 square feet basically that we're over with the coverage. The bulkhead is being increased in size by 22 square feet. In theory, yes, you could technically, shave that off, I guess, but it's pretty bad. So if they wanted to bring both requests together.
The bulkhead's it's entirely within the setbacks and everything. So
Yes. Outside of the, setbacks. It complies with the setbacks, yes.
Better way to say it.
No.
Okay.
I got you.
Yes, Mr. Ram.
There's just one thing about this that is making me curious. What is the hoist crane beam that runs the length of the second floor? Just raises questions about what exactly is taking place up there.
You always find the one question that I can't answer. You're very good at that. I will let Adam answer that question. He seems inclined. So
that's for when I'm no longer able to carry heavy things into the attic of the garage.
Okay. Just please say who you are.
Oh yeah, Adam Rudig, 70 Highland.
What's the expected capacity of this?
A couple 100 pounds, maybe 500 pounds. I don't think it'll ever carry anything that big, but
Okay.
just so you can get bikes and skis and things up there to store for the
Very
winter.
good thinking.
Okay, thank you.
Thank you.
Thank you. Does anybody else? Any other questions? No? Okay, thank you.
Okay, thank you very much.
Okay, is there anyone to speak in favor of this petition? Anyone to speak in opposition? Anyone to speak to, for, or against? Public hearing is closed. Yes.
I'd like to make a motion to approve the variance application as presented and advertised.
Is there a second?
Second.
Yes.
So, there's no change in the lot line conformance or lack of conformance. It's still 2 feet on either the back or the side yard. So there really is nothing much to think about there. And the overage in terms of lot area coverage, it's one of those decimal point infractions. It's really 25.7% or something like that instead of 25%. It's barely worthy of consideration, but we are here to consider it. So I think it's, let's just say it's de minimis, and that helps. The variance not being contrary to the public interest or the spirit of the ordinance, purpose must not conflict with the explicit or implicit purpose of the ordinance. Again, with clearances, we're trying to make sure that we don't encroach on airflow and light and sunshine and so on and so forth on surrounding properties. Since this is replacing very much a similar structure, that there is really no change in conformance there. Substantial justice being done. There's no loss to anybody else in the neighborhood for replacing this garage with another garage. The changes in dimension are reasonable. Values of the surrounding properties won't be diminished. A new garage is good for the surrounding properties as well, especially since it's tastefully designed to fit in with the characteristics of the neighborhood. It does not have an upward extension that would create long shadows and not fit. It fits in perfectly with what's there and what's in the surrounding properties. Literal enforcement of the ordinance would result in unnecessary hardship. I mean, really, when you come down to the lot line, the setback encroachments, if you look at where the garage is located on the property, you really can't bring it much farther away from the back property line because you're really starting to get parallel with the house and really be crowded there. And you can't likewise move it in. Did I say the rear property line or did I say the right property line? Anyway, either property line, you can't really move it away from the property lines without kind of bumping into the house. So this is the logical place. It's where the driveway is. That's a special condition for the property, and the existing structure is a special condition, which really militates that this is the right location for the garage. And that is my motion.
Mr. Neese?
I have nothing to add.
Okay. There's no further discussion. We will vote. Mr. Neese?
Yes.
Mr. Mannel?
Yes.
Ms. Margison?
Yes.
Mr. Bayham?
Yes.
Mr. Rossi?
Yes.
Mr. Mattson?
Yes.
And the chair votes yes. And thanks you for your patience.
We're staying, right?
Yeah. Okay.
We're going to congratulate Mr. Mattson finally.
Are you, this is just his
Oh,
first
yes.
year? Wait, don't you have to go through another meeting? or
Yes,
just-
but I saw, yes, I'm on the
Finally,
agenda.
you, right, finally.
I've been
But-
patiently waiting.
What are we congratulating?
So I
have
applied
to-
back in December to be reappointed, and I'm finally on the city council agenda now.
Isn't that
Oh, good.
crazy?
Very good.
Well, I think, yeah, stuff.
Anyway, there will be one more meeting before he's official,
Yes,
but
I
yes,
have consideration.
we are glad you're on the way.
I am glad as well.
Move to adjourn?
So I do just have to say, on the enriching your word power, I had never heard the word militate before. It was used by both
Oh, I
Mr.
know.
Rossi.
Yeah, I thought about that too.
And,
I know.
It's a legal word.
yeah, I had to look it up, but thank you for enriching my vocabulary.
Pays to increase your word power.
Yes.
And the vice chair used it as well, so.
We
You know,
try
the word
to,
I always want to
try
use
do
is de
something good for
minimis,
you
but I
every
don't feel I have the right credentials.
I use de minimis all the
I
time.
know,
We
but,
adjourn?
no, okay, sorry. Would someone like to make a
I would
motion?
like to move that we adjourn.
Second? All in favor?
Aye.
Okay, thank you.